Good afternoon. It is February 26th, and we're starting hearings in House Economic Matters. First bill we have today is House Bill 1096, I believe. Yes, 1096. And this is your panel, sir. You may begin.
Yes. Well, thank you, Mr. Chairman, Mr. Vice Chairman, members of the House Economic Matters Committee. It's a pleasure to be here before you to testify in support of HB 1096, Fraud Prevention and Worker Protections Act. This is the top priority bill for the offices of the Attorney General this session. I want to thank you for giving me an opportunity to testify on behalf of the bill. And as I mentioned yesterday, you'll never find an Attorney General leaving the office without their capable subject matter experts. So you're going to hear from Heather Heilman, who's Assistant Attorney General, who focuses in this area of the law, and one of my Deputy Attorneys General, Leonard Howey. He'll introduce himself. He's a former Secretary of the Maryland Department of Labor, a former Deputy Secretary of the Department of Human Services, and you'll hear from him as well. This bill is about fairness. It's a lengthy bill. I suspect when you pass this bill out of committee to the floor, it will not look like what it looks like today. It's gone through revisions. We've had stakeholder engagements from those who support and those who oppose, and we've tried to incorporate the changes along the way, recognizing that during the legislative process, and I hope that this, as a minimum, would go to a subcommittee or work group, we can continue to refine and fine-tune those areas where there is consensus in this bill. And why is that? Because I think Maryland workers deserve fairness and accountability in the workplace, and they deserve to receive wages and protections that they are legally entitled to. Wage theft and worker misclassification are not just technical violations of labor laws. They are systemic problems that strip workers of fair pay, benefits, and workplace protections. These practices allow unscrupulous businesses to profit at the expense of Maryland's workforce, undercutting law-abiding employers and costing the state millions in lost payroll, taxes, and contributions to unemployment insurance and workers' compensation funds. The need for urgent action is clear. Maryland's current Workplace Fraud Act is simply inadequate. It applies only to construction and landscaping, and even in these industries, misclassification continues unchecked. But the problem is not confined to these sectors. Misclassification has spread to industries such as home health care, security services, janitorial work, and housekeeping, where low-wage workers are especially vulnerable to exploitation. House Bill 1096 addresses this gap by expanding coverage to all industries, ensuring that no worker in Maryland is left unprotected. More than just expanding the law, we must address the enforcement failures that have allowed these violations to persist. As this committee has seen, the number of citations issued by the Labor Commissioner is strikingly low. Even when violations are identified, the penalties imposed are often insufficient to deter wrongdoing. This is not a commentary on the personnel at the Maryland Department of Labor, whether it's the Commissioner of Labor, certainly not the Secretary of Labor who are here to testify on this bill, and certainly not the men and women in the workforce at the Department of Labor who are responsible for doing this work. The framework of the law is inadequate. General contractors often escape accountability for misclassification taking place on their job sites. Instead, penalties are unfairly levied on subcontractors who often operate thin margins. House Bill 1096 corrects the injustice by holding general contractors accountable when they turn a blind eye to wage theft and misclassification. And the stakes couldn't be higher. Consider the recent actions taken by the District of Columbia. And I want to preface these two cases by saying this is not Attorney General envy. This is not a question of look what my colleague is doing and boy do I wish I could. This is about look at how workers are being protected in the District of Columbia and how they ought to be protected in Maryland. Last year, my colleague Brian Schwab. He filed a landmark lawsuit against 5 construction companies and labor brokers, many of them who not only do business in Maryland, but some of them are headquartered in Maryland, for orchestrating a widespread illegal worker misclassification scheme. The lawsuit alleges that over 370 workers were cheated out of wages and benefits. We do not bring those types of actions in Maryland. But my colleague Brian Schwab's office didn't stop there, because just a month later, after they filed the landmark action, and one might say anybody can file an action, just a month later, the District of Columbia secured a $3.75 million settlement in the district's largest ever workers' rights enforcement action. As part of this case, several construction companies, again, who also do business in Maryland. District of Columbia is not that far, okay? And that line that separates Maryland from the District of Columbia does not prevent bad actions from coming into Maryland. $3.75 million settlement, largest ever. As part of this case, several construction companies were required to overhaul their payroll and sick leave practices, and one company agreed to $1.7 million in restitution to 1,200 harmed construction workers. $375 million, 1,200 workers, one case. In comparison, and these charts may have been provided to this committee, but they were provided to the Senate Finance Committee last year. In fiscal year 2024, Maryland issued 18 citations under the Workplace Fraud Act. Workers found to be misclassified, only 81 in fiscal year 24. 81 workers found to be misclassified, 18 citations, and in the District of Columbia, they are running circles around us. They're running circles around us. This is happening in Maryland. The massive enforcement action not only held companies accountable, but also returned millions to workers who had been denied their rightful pay and benefits. This is the kind of impact Maryland could achieve if we provide the Attorney General's office with the tools it needs. The same issues we see in D.C. are happening right here in Maryland, and it's time to act. House Bill 1096 strengthens enforcement by equipping the Office of the Attorney General with the power to investigate and pursue legal actions against violators. Other states like Minnesota and Illinois have given their attorneys general concurrent enforcement authority, and they have been successful. Maryland must follow suit to ensure that bad actors cannot evade justice and that workers have a real path to recovery. We cannot afford to continue to turn a blind eye. The lawsuit in Washington, D.C. is just one example of how strong enforcement is crucial to curbing misclassification and protecting workers. And House Bill 1096 will give us the tools we need to tackle wage theft and misclassification head-on, leveling the playing field for all Maryland workers and for those Maryland employers who are playing by the rules and doing it right. So for these reasons, I urge a favorable report on House Bill 1096. Thank you, Mr. Chairman.
Are they here for questions, or are your people want to present as well?
They're going to present as well, Mr.
Thank you.
Chairman.
Whoever would like to go next, please.
Who's going next? Heather.
Okay. Good afternoon, Chair Wilson and the committee. Can you all hear me? Okay.
Just pull it right. Nope.
Oh, okay.
There you go.
Thank you. My name is Heather Heilman. I'm an Assistant Attorney General in sort of the nascent Worker Protection Unit in the Office of the Attorney General. I'm just going to walk you through some of the highlights of what's in the bill. I'm not going to get to everything, and I'm happy to take or do my best to answer your questions afterwards. So the heart of the bill is that it amends the Workplace Fraud Act in significant ways, as the Attorney General mentioned, primarily by expanding it to all industries. I do want to be clear, though, that misclassification of employees is already illegal in all industries. This is just going to expand the tools of that law to all industries. It creates liability for general contractors, higher level contractors, and successors. It prohibits employers and employees from contracting out of coverage of the law. It increases penalties under the law. introduces licensing consequences for those who violate the law and debarment consequences for those who have had 2 citations under the Workplace Fraud Act. And it allows the Attorney General to litigate to enforce the law. I do want to be clear that it does not change the existing ABC test in the law. That might be controversial. What I mean by ABC test is that there is an assumption that a worker is an employee unless they meet sort of 3 prongs that would indicate, that would show true independence in the work. The bill will also allow the Attorney General to bring an action to enforce the Maryland Wage and Hour Law, the Wage Payment and Collection Law, and the Prevailing Wage Law. It amends the False Claims Act in such a way so that false statements given to support the underpayment of unemployment insurance premiums could be addressed through that law as just a different way a different tool to address misclassification. And finally, dear to my heart, it creates the Worker Protection Unit in the Office of the Attorney General and gives it the authority to conduct investigations into misclassification and wage theft. And I will leave it there, but as I said, I'm happy to, try to answer your questions. Thank you so much.
Okay, good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. The Attorney General started by saying that this is not an issue of people, it's about framework. I just want to give a couple minutes here to talk about the framework of how we actually got to where we are today. In 2009, when the Workplace Fraud Act was passed, I was then Deputy Secretary at the Department of Labor Licensing and Regulation. We began with eyes on the reported wage abuses across a variety of industries that included delivery services, home health care, and food service. But as we all know, after negotiation and compromise, construction and landscaping were the only industries that ended up as being subject to enforcement. When studying the landscape of worker misclassification back in 2009, we actually went out and met with states who consolidated their misclassification authority within the state labor agencies, as well as those that provided independent authority with their state attorney general. New York was one of those states. We visited New York, and they continue to be a misclassification enforcement model. The act was amended in 2012, as we all know, to provide whistleblower protections. But also in 2012, that's when I returned to the department as secretary. My personal background is actually important in this context, just to let you know that we really do understand where the Department of Labor is coming from with their thoughts, with their concerns, especially those regarding concurrent jurisdiction. After all, there was actually a reason that we did not include the Attorney General in the original bill. It wasn't out of a fear of confusion or of duplication of effort. It was much more simpler than that. At the time, workplace fraud was my agency's highest priority initiative, and we guarded it jealously. Besides, the state, we all know, was just coming out of the Great Recession, and the OAG at the time, they had their hands full with compliance with the American Reinvestment and Recovery Act and trying to put the legal framework in place for the mortgage foreclosure crisis. So a lot of the framework that was established was really because of the motivations that we had in place. We have no desire to tread into the lanes of the Maryland Department of Labor. We understand what the lanes are, and we'll guard those fervently. Just to conclude, the Office of the Attorney General today is far different than it was back then. Attorney General Brown has placed us really at the forefront of protecting workers along the lines in our Civil Rights Division, Consumer Protection Division, False Claims Unit, and our Criminal Division. So this effort has really helped to connect the dots and give us the tools that we need to actively enforce and represent the interests of all Marylanders.
Okay, thank you very much. Mr. AG, as a obvious respect, I'm going to begin what I assume is going to be a blistering number of questions. It's going to be directed to, I guess, Mr. Howie or Ms. Heilman. Obviously, feel free to jump in if you like. And I know we're going to have plenty of people joining me, but I'll start this out. At this point, the Department of Labor can they already have access to unemployment records, workers' compensation records, and tax records, correct? Is that, am I about on point as far as investigating workplace fraud? Is that correct, Mr. Howe?
Correct.
Okay, and I know we just hired we gave them 5 pins last year, Department of Labor, to do these investigations, because the complaint was they weren't being done before. And obviously, I'm looking at a chart here, and then from 2002, there were none, 2003, there were none, and then calendar 2004, once we got them their pins, looks like there was at least 295 sites visit, 1,687 workers interviewed, 185 investigations, 199 found to be misclassified, and there were, in addition, 243 referrals made to state agencies. You're aware of those numbers, correct?
Correct.
In addition, they, because they also have access to the unemployment insurance audits, there were, and I guess the 5 big ones we always look out for: healthcare, landscaping, janitorial services, and construction security guards. I think they recovered roughly 31, was that right? Total unreported wages found $31 million just in construction, in addition to $10 million for healthcare, $2 million for landscaping, about a little over $1 million for security guards. And you guys understand that was what they found last year, right?
Correct.
Okay. I guess, so my question is, it sounds like the Department of Labor is doing something.
I'll jump in, Mr. Chairman.
Please.
They are doing something. They're not doing enough, and it's not because they're not working hard. What they're not doing, and I sometimes use the state's attorney's office as an example, right? Although this is not criminal that we're talking about. I'm going to give you an example. You got state's attorneys who every day have an automatic docket, and they're seeing cases all the time. A lot of misdemeanors, shoplifting, bigger cases, carjacking, and they do major crimes as well. I also have an organized crime unit. Well, why do you have an organized crime unit? You got state's attorneys around the state that are doing that work. Because we do something that they don't do. Not that they couldn't do it, and sometimes we actually train them how to do it. We do long-term investigations. We do the wires. We do the confidential informants. We do the long-term surveillance. Not to say that they never do that. We play a different role that complements what they do. We do not have, Delegate Rogers, what we say in the military, overlapping fires. We just don't. So they're doing a great job. They're not bringing the $3.7 million cases. Now, I made a comment to the business chamber, Mr. Chairman, in a stakeholder meeting. We were trying to kind of, listen to their concerns, et cetera. And I said something I think that they took out of context. And what I said was, when we get a complaint at an employer, right now, the Department of Labor, they'll look at the records that you mentioned, Mr. Chairman, and they're going to look at the 2, 3, 4, 5 complaints that they got, and they're going to resolve them. We're going deeper. We're going deeper. We're going to look at this employer and how they use as a business model wage theft, misclassification, and other misconduct as a business model. When they're just getting citations, and they're not going to court for these citations, these are administrative citations, that is a cost of doing business for them. But when you disrupt their business models like they did in the District of Columbia, that we will do, that's when you're going to make a real impact. So we're not suggesting they're not doing work. We're not suggesting that their numbers aren't going up. What we're suggesting is the Office of the Attorney General needs the authority to bring the very disruptive types of actions that you see other OAGs bring.
And I'll say, again, being a former prosecutor in that time, I felt more like you guys just took the sexy stuff and left the junk to the rest of us. So it kind of sounds like
I knew I was going down the wrong track with that metaphor.
And I say that because, but right now, you're not prevented from getting involved. In fact, the state agencies are required under Labor Employment 3-910 to work together. So this information that they have, you can also get it. And in fact, they can refer cases to you, correct?
Partially correct, Mr. Chairman, if I may explain.
Please.
Okay, we cannot bring a case unless referred to us by the Labor Commissioner. And the reality is—
So I was correct.
Yes, and the reality is we don't get referrals. We received 1 or 2 recently. How many did we get recently?
Well, and let me just, we are, in fact, at this moment, working with the Labor Commissioner on a case. However, the structure of the Workplace Fraud Act doesn't even allow the Labor Commissioner to litigate, only to use the administrative process. So right now, a private party can hire a private attorney and can litigate this issue, but neither the Department of Labor and Industry nor the Attorney General's office can do so.
You can't. So if they ask you to, you can't help them.
We can't go into court for them, no.
You can't.
Well,
So-
we can't, if there's a citation that's issued and the employer doesn't abide by that, we can seek judicial enforcement, but we cannot bring the types of cases that they brought in the District of Columbia and they're bringing in other states.
And so we'll move on to the next part, and this is obviously the part that concerns me the most, which is the warrantless search, because that's in fact what you're asking for. Courts have allowed warrantless administrative searches in some businesses that are deemed closely or pervasively regulated. That's the New York v. Berger case from 1987. Maybe I'm reading it wrong, the junkyard case. In Maryland, we have opened that statute up to construction and landscaping. And other examples are like oil drilling, coal mining, things of that nature, things that are predictably dangerous. That's my understanding of the current law. And so Maryland Department of Labor can currently inspect without a warrant these two types of businesses, construction and landscaping. Is that your understanding?
I won't argue with you on that.
Okay, and so the issue is this bill, the way I'm reading this bill, would allow the AG to enter any business in Maryland, observe work being performed, examine and copy records, books, registers, payroll records, and any other records related to compliance with the subtitle without a warrant. And it says, the wording is the commissioner's own initiative or on receipt of a complaint. So there is no reasonable articulable suspicion needed. Is that your goal?
No.
Because that's
If
the
the
way it
business, Mr. Chairman, if the business we can show up at the door, okay, we can ask to come in, and if they say no, we've got to get a warrant.
And what happens, what's the penalty for, as you stated in this bill, hindering an investigation, sir? It's $5,000. So my clients that I represent in criminal cases, if somebody comes to their door looking for a murder weapon, and he slams a door in their face, he's exercising his constitutional right. But according to this bill, if they exercise what I would argue a very similar constitutional right, they automatically get a $5,000 fine for hindering. Is that correct?
Mr. Chairman, if I may explain.
Please.
Yeah. I know that what often happens is there's a parade of horribles, this idea that the Office of Attorney General is going to blow through doors and do. You have already provided the Office of Attorney General with similar power in other areas, consumer protection, and every year, many of you are asking us to do more. And I have the ability to do what we're asking here. In the case of Medicaid fraud and vulnerable victims unit, I have the authority to go into nursing homes and assisted living. So I have similar authorities in other areas for different purposes. So,
But that doesn't change what the Supreme Court has said, and it doesn't change the fact, as we're talking, any business records, because my concern is this. You go in with no reasonable articulable suspicion, just because you choose to. Is there something, ma'am, you're shaking your head, is there somewhere in the bill that says that that's not true?
go ahead, you want to take that?
Yeah, so, the Attorney General under this bill has very similar powers to what the Labor Commissioner already has to investigate, complaints of misclassification. If we go and we don't get cooperation when we ask to see records, we have to go to district court and show probable cause. So it's not, just we're going to look for anything.
So you're saying here, if you go, I want to, because you're not correcting me, but if when you get that probable cause, they get a $5,000 fine automatically.
No.
That's not what this bill says?
No, and Mr. Chairman, I mean, I know we can spend a lot of time. If that's what the bill says, and there's a draft and error, that's not our intent. That is not our intent.
So is your intent to allow somebody to say no?
Absolutely,
and
then we will do what we do in consumer protection, Medicaid fraud, and quite frankly, in our criminal unit. So we're going to go get the necessary court orders.
So you do not want a penalty for somebody refusing you, or as it says, hindering?
No.
Okay.
We want
great.
people to exercise their rights to privacy. There's no doubt about that.
Also, to be clear, when you're, and I apologize, it's not automatically, but you can ask for it to be imposed merely because they refuse. That's how the current bill is written.
Then we should fix that, Mr. Chairman, because that's not our intent.
And I say this because, as I'm moving forward, because when we're talking about, we're searching for administrative stuff, right? But when you're going through their books, and we've seen from, especially, and I say this, like when you're investigating the mob, you start out administratively, and so any criminal thing you find while searching through their business, their records, their books, you can then go after them on that, even though you never had a warrant, correct?
That is no different than the existing law, Mr. Chairman.
Which says what, sir? Because
If my Consumer Protection Division goes into a business, okay, with the proper documentation and authority, and they uncover criminal activity, they are going to make a referral to the proper authorities.
unless it's a pervasively regulated industry, the proper regulation and authority would be a warrant.
And what I'm saying, when we have lawful reason for being there, if we uncover something that's a criminal conduct outside of what we're doing, we're going to refer it.
But that's with a warrant.
And what we're suggesting, Mr. Chairman, is that the bill should be drafted to follow current law. So if it's not currently drafted that way, and that's why I started my testimony, we are willing to work with the committee to make sure that it is clear.
And I'm trying to find out your intent. Is your intent to do warrantless searches with no reasonable particular suspicion or probable cause?
No, my intent is to be able to go to a business, ask for entry. When they say no, get the proper authority that I need to be able to enter with the requisite level of suspicion or probable cause.
So let's step back on that. So is your intent to only upon receipt of a complaint be able to exercise that, or do you want to be able to do that randomly without said, complaint?
The Office of the Attorney General is a complaint-driven organization.
I agree.
So it is with complaint.
Because again, I'm just going by what I'm reading.
We are a complaint-driven organization, and that is true for all of the work that we do.
Okay, because as I said, and this is something I'm always really concerned with, and I think as a body here, we have shied away greatly from allowing the overpowered government, because as African-American business owners, because we'll step out, because usually it's criminal laws, we try to, because they seem to be held against us to a greater extent. We seem to be, whenever a cop smells weed, it tends to be in the cars of people that look like me. So giving law enforcement an opportunity to do warrantless searches is something that many people that look like me would be a little nervous. And many black business owners, I would say, would also be nervous. So I'll look into that.
Mr. Chairman, as one black man to another black man, I fully understand what you're saying.
And then you understand light skin violence, how we always go against you. So let's get on to, so let's make sure. This bill also proposes that a general contractor be liable for the actions of their subcontractors. So why would any, and this is where the whole small minority business thing comes in, why would any big company ever contract with a new small business owner if he's gonna be liable for the misclassification or wage hour violation? Doesn't it seem like people like me that start a business may be a little less likely to get hired because this person hired me on is gonna have to assume all of the things that I've done wrong in the past? Because that's the way
I can't really speak.
The way the bill's written, sir, is it seems like it would have a chilling effect for new businesses because, in fact, what it does, it says it strikes the safe harbor provision that's currently in there, and it says which require general contractors to verify through an affidavit that a subcontractor has unemployment insurance, things of that nature, right? But my concern is the way it's lined up is I feel like it's going to create a great tension because if you have a GC, general contractor, and he's putting himself at risk every time he engages with a subcontractor, and it seems like it creates an ongoing duty of the general contractor to continue because if, let's say one day the subcontractor, GC and the subcontractor have a great relationship, he goes out one day because he's short a guy and he picks up something from Home Depot. From this point on, it doesn't tell the GC, that GC is now responsible for that bad action. And I know what you're gonna say, but that GC can then be reimbursed by the subcontractor for all, liability, legal fees. The problem is these subcontractors are small, so the chances of them just not fleeing or going out of business are between slim and none. So is that your intent to make sure that whatever that GC has done, and I'll get to successor liability in a minute because I'm not there yet. Mm-hmm. I'm talking about current liability, that whatever that GC does or that sub does, that GC is responsible for all of his violations.
Yes, yeah.
That's your intent?
The answer is yes. I mean, we
Okay.
expect general contractors to police their subcontractors, absolutely.
And create an ongoing duty. Like I just said, the example I gave you, where he hires somebody because the sub is shorter man, he hires somebody, brings them in from Home Depot, that GC is now responsible for that.
Yeah, and we're not shying away from that. We expect general contractors to police their subcontractors, absolutely.
And how do you police stuff like that, sir?
We'll leave that to general contractors to make sure that they abide by the law.
That's not- my point is-
I'm not in the construction industry. You're going to hear from those in the construction industry that are better able to speak to that issue, Mr. Chairman. But I can tell you it is not unique in Maryland law where we hold parents reliable for affiliates. And when I say parents, I don't mean parents like and my son. I'm talking about parent companies liable for affiliate companies. This is not a new concept in law. Where parents are responsible for affiliates or subsidiaries.
But this one is regardless of any due diligence of the general. And like prompt payment, there's a due diligence. Like I said, you guys cut out the safe harbor, which I don't, and that was your intent, right? That there is no safe harbor provision like there is in the prior law. Is that your intent?
Yeah, I mean, we're
Yeah.
That's your intent, okay? Obviously, I strongly disagree, but we'll move on to the next one, which is you also create successor liability. So if Company A acquires Company B, then Company A is now on the hook for any prior violations that was done by Company B. Correct?
Yes.
Yes,
And
and
that's your goal.
if I can explain, Mr. Chairman,
Please.
okay, and you may hear this in testimony from the others who come up, it is not uncommon during a long-term construction project for companies to be sold from one another. Now, I understand right now the focus is on, in your line of questioning, on protecting the general because of the bad act of their successor. But I'm asking the committee, don't lose sight, because at the end of the day, this bill is about protecting workers. And if generals aren't policing successors, guess who's losing? Workers. That's your constituents. They're losing. They are black and brown mostly. They are Spanish-speaking mostly. They are women mostly. They are folks who are otherwise looking to public assistance because they're getting their wages ripped off. So unapologetically, Mr. Chairman, we are asking for generals and successors to be held responsible.
I just want to make sure, so the answer is yes, because
Yes.
I will say that our job here isn't just to protect workers.
Yep.
It is to protect business owners and make sure they have rights, because as I've learned, being a business owner is basically the best way to free yourself. I want to see people that look like me signing the front of the check, not just the back. But we'll move on. So the next part, so when we talk about that hypothetical, so in that hypothetical, if Company A buys Company B, who has some distant past wage or hour violation, and then Company A gets a new one, now he is categorized as, because normally be unknowing, and they get the $5,000 on your first, $5,000 to $10,000. It's automatically upgraded to knowing because it's his second one, and now it's $10,000 to $25,000 per violation because he purchased a company that sometime in the past had a violation. Is that your intent?
I've had difficulty following that hypo.
Okay,
but
we'll do it again.
If
I'll
it's
do it again.
consistent with successor liability, yes, that's the
So-
intent. If it's consistent with generals responsible for subs, that is the intent.
To make sure. So if he buys a company that years past had a violation, and then he now owns that company and gets a violation, he is now known as a knowing instead of, it's automatically upgraded by this bill to a knowing violation. And so instead of a $5,000 to $10,000 violation, it's a $10,000 to $25,000 violation, and that's your goal.
Yeah, you said a number of years, so I don't know how many years you're talking about, because there are also limitations in these actions.
We could go 5, we could go
Right.
7, we could go 2.
Yeah, so we look forward to working with the committee on
Okay.
establishing what appropriate look-back period would be.
And also to be clear, because this is something else I was a little taken aback by, as we know, there's already a private right of action for these type of violations. It's already out there. They can already bring suit for misclassification and wage and hour violations, getting treble damages and attorney's fees. Is it your intent that the AG not only be able to get treble damages, but also attorney's fees?
The way
Yes.
it's written now. yeah.
The way it's written.
Okay,
And
and
if, Mr. Chairman, if you want to take that out, because I'm not certainly distributing that to my attorneys, it would go to the general fund, because all attorney fees recoveries in the state of Maryland go to the general fund. If you want to take
I'll say
that
this
out.
as plaintiffs and the defense attorney when it comes to some of these businesses. The biggest threat in most of these cases that I've represented is the attorney's fees. It's not the trouble damages. It's not somebody who's accidentally an hourly, but they should have been, or salary, and they should have been an hourly employee, and that $8,000. It's the $80,000 of attorney's fees that stack up. So my concern would be that the AG would now be able to threaten attorney's fees in the same way the private industry does. But you're saying that's not important.
No, Mr. Chairman, the hierarchy of priorities in the Office of the Attorney General, this is not new to me.
Great.
This is a long-standing tradition. Our first priority is always to recover restitution for Marylanders. Our second priority, and it's neck and neck with first, is to achieve adjunctive relief. Stop doing the bad work. The third priority is to impose whatever penalties exist in law, and those penalties rarely go to the Office of the Attorney General. They go to the general fund, and we rarely, if ever, recover attorney's fees because I don't think we have them in most of our actions. If attorney's fees is something that is offensive to the committee, certainly we can do without it because, again, it doesn't come to the OAG. It comes to the state of Maryland, the general fund, which right now, as I know, is in desperate need. But we don't litigate for general funds. We litigate for restitution and injunction.
I appreciate
But
that.
I would ask, though, if you do modify that, please don't take that attorney's fees away from the private litigants because they're going to need it because these are poor people who are getting ripped off.
That's why
and
it's in there,
attorneys
sir.
represent them because they get the attorney's
Most people
fees.
know I don't like private rights of action, but we've left it in there for that purpose, so I too understand. My last part that I have a question on this is also the existing law has a carve out for gig workers. They call them exempt workers. DoorDash, Uber Eats, things of that nature. They're no longer exempt under your bill. That's a dramatic change, and I'll say, especially with the ABC test, because to my knowledge, and to people that I know that work for these places, they pick their time, they pick their hours, they pick their car, they pick their uniform, they log in when they want, they leave when they want. But under your bill, gig workers are now pulled in, and they're now pulled in under this bill. Is that your intent?
Our intent is to apply the standards for who is an independent contractor and who's an employer. And if a gig type company can meet that test that you are an independent worker, fine. I should point out to the committee, and you have read this, they are losing across the country, right?
Who's they?
Uber and Lyft and a lot of these gig companies are losing across the country. Maryland is one of the few states where they're getting a pass, and they have workers who work at their direction, at their control, and they're called independent contractors. And guess what? They're losing those cases around the country. But in Maryland, I'm just saying, Mr. Chairman, in Maryland, we're not changing the test as Ms. Heilman mentioned.
Right.
So while the bill applies to all industries, that doesn't mean that in every industry there's no longer independent contractors. You just got to meet the test.
Then why?
And if Lyft or Uber are going to testify today, maybe they have concerns that they aren't going to meet the test.
Well, I just know from friends that drive those, I don't see how that's humanly possible as an attorney, that when you get to decide when you want to be a Lyft driver, and some are Lyft and Uber drivers, I don't know any other industries that allow you to work for yourself and the competition. But again,
they should have no concern then, Mr. Chairman.
Well, I guess the problem is it's the part of the bill, because if that's the case, then why strike that carve out of exempt persons?
Because we believe that this should apply to every industry, Mr. Chairman, because we think that workers in every industry ought to have protection. And that doesn't mean that every industry has bad actors, and it doesn't mean that every industry where there may be independent contractors shouldn't have independent contractors. We're talking about applying the test across the board in every industry, and if someone is violating the law, then the workers get the protections.
As I understand the way the test is going to be applied, is you're going to show up without a warrant, according to this bill, decide to open up the books, go through, stack as much information as you can, talk to as many people as you can, and basically put the threat of God behind you. So where anybody is going to do whatever they can to settle, versus like I was describing, a Uber driver that's just picking what he wants to do, but gets fired for some odd reason, brings this complaint up. My concern overall, sir, is beyond the hilariously high fiscal note, but we'll get there, is the impact that you think this has in a current state where our businesses we're going to be going to them in the next few weeks like a bank. We're going to be asking more of them because we need them. The federal government, as we've seen, is not going to be what this state's going to be depending on in 5 years. So this amount of pressure, the warrantless searches, the overall message we're sending definitely doesn't sound like Maryland is open for business. It's like, should just say businesses beware. because we are coming in whenever we want, for whatever reason we want, and we will look through everything you have. And that's what I'm worried about, sir.
Objection, compound question.
But so I think that's all the questions I have. What the last one? How many people you need?
Right now, I'm not asking for any, and I'll tell you why. Because even without this authority, I've designated 2 pins. Ms. Heilman is one, and I have an investigator, and we're doing the best we can with the authorities that we currently have, but we're not making a whole lot of progress. So with the new authority, Ms. Heilman and my investigator will be able to do more, use the existing authorities and these authorities, and when good times return to Maryland and the budget turns around, yes, we'll be in and asking for more. Why? Because we're going to return $3.75 million to Maryland workers. We're going to help 1,200 workers who have been harmed in one lawsuit. That's why, Mr. Chairman.
But it does say that the unit staff includes assistant attorneys general, investigator, administrators, and other personnel, as well as salaries of the chief counsel and staff and expenses for rent, travel, equipment, supplies, general operating expenses necessary for the work of the unit and shall be provided by the state. That's what your bill says.
And what I would ask, Mr. Chairman, as you and the committee have done on many occasions, sometimes, over my objection, give me the authority. I'm going to work it with existing resources. Gotcha. And Mr. Chairman, I'll just finish, and I know you said it was your last question. I just finish look, at the end of the day, I bring you this bill. Okay, and you have a choice. Are we going to provide greater protections for workers or not? Maybe not 100% of what's in this bill, but are you going to make steps forward or not? Are you going to protect bad actor businesses? All of the businesses that you're going to hear from today, they're all good actors. They're good actors. And their testimony doesn't protect them. It protects the bad actors who did not come to the hearing today. It is a policy decision. The Office of the Attorney General, we will use whatever resources we give you. If you don't pass this bill, we're going to do our level best, and we're going to watch our neighbors run circles around us when it comes to protecting workers.
And for everybody else in the audience, you don't get the closing statement that the AG gets. Give him time for a closing statement on his bill only. That's the benefit of being an elected official. The rest of y'all don't answer nothing that ain't been asked. Thank you.
Thank you, Mr. Chairman. I appreciate you. I do.
Delegate Pruski.
Thank you, Mr. Chairman. I'm not an attorney, but I play one on TV. On page 18 and 19, this is just for me reading the bill, the subpoena process. So the Department of Labor right now, if they request a subpoena, or how does that process work now?
Right.
Then what the bill is. I need to understand it because, again, there's some language in here in regards to that. So can you explain that to me?
Right. So the Department of Labor comes to the Assistant Attorney General at the Department of Labor. If they need a subpoena, they will go to the Assistant Attorney General. And the provision in the bill is really to help address some of the concerns that raised by the chair that, hey, we need a subpoena to do what we're doing here. So that's why it's in the bill as a separate provision. But under current law today, if the Labor Commissioner needs a subpoena, the Labor Commissioner is going to go to one of the Assistant Attorneys General at the Department of Labor who's going to go and get that subpoena.
Thank you.
Thank you, Mr. Chair. I'm not really sure if I want to follow any of this up, but I'm going to give it a try here. Mr. Attorney General, great to see you as always. Last year this committee had a lot of discussion on a bill that actually I brought forth around revamping how we deal with misclassification here in the state, especially when it comes to the penalty provisions, which we increased, I believe, and the enforcement referral process, which we changed around as well. My question is, we just passed that bill last year. And now the OAG is here saying that we actually need more teeth around that, which I'm not saying I disagree or agree with. But with all due respect to the Department of Labor, you're saying the OAG has all the enforcement possible to kind of do this. So why do we need the MDOL involved in this process at all? Why can't this just be with the OAG?
Just with the OAG?
Yeah.
No, we do not want to take it from, no. Just like I wouldn't ask you to give me all the prosecution authority and take it away from state's attorneys. Just like I wouldn't, say that, hey, take away the Consumer Protection Authority of Baltimore City and let me do it all. No, I think it makes sense when you have a number of entities. You're going to hear from the Department of Labor in their written testimony. They'll probably testify today that, this is cooperation and integration. This is big stuff. This is hard to do. This is what we do in the OAG. We do it better than anyone in government because we have to. We coordinate and integrate across government because that's how you set up my office. I represent every state agency. I've got AAGs. We know how to coordinate. We know how to integrate our activities. 2 years ago, I came to you. I said, please give me Civil Rights Enforcement Authority. And some of you rightfully said it was a different committee. Well, wait a second, the Maryland Civil Rights Commission has it. Why do you need it? And won't it be confusing? What about cooperation and integration? And won't employers be confused? And today it's working well. And we're bringing cases that the Maryland Civil Rights Commission doesn't bring.
Okay, well, you just kind of answered my second question, which was about the concern of confusion, right? If you're a small business owner here in the state and all of a sudden you get something from the Department of Labor and the AG, you can see how that could be confusing for folks, but you just said that it sounds like you guys are doing this in existing areas of the law. My last question, and this could be for your staff here, just so we kind of get a grip on misclassification in the state. How much are Marylanders losing out on estimated when it comes to misclassification?
I think the numbers are, I don't know that there are good numbers, but it's at least in the tens of millions, if not reaching the billions.
Okay.
Yeah.
It's astronomical.
And you probably, I think you have some written testimony that probably has some good statistics on that as well.
Thank you, Mr.
And Joe, on that question that you asked about the coordination, I think you're going to hear from the Department of Labor. I think it's in their written testimony. We certainly have had conversations with them. We can certainly work it out with Department of Labor to clarify those coordination issues, those integration issues. With the Maryland Commission on Civil Rights, you put in statute, we have to create regulations between the two of us. So whether it's regulations, you put in statute, you have to have a memorandum of understanding. If I get a call, a complaint, before I act on it, we're contacting DOL. Hey, you guys get anything here? No? Okay, we're going to act on this. Oh, you want this? You're better suited? Boom, you have it. You can put that in legislation. There's no issue that you are going to hear today in opposition that cannot be fixed in an amendment, except the pure opposition that this is just a bad bill. But when you hear about the details well, the bill does this, and a lot of the good points that the chairman raised, you can fix that by amendment. Okay.
Well, you just prompted another question, Mr. Attorney General. Is there any other state that is doing it in this manner where the Maryland or their Department of Labor and the AG both have kind of dual enforcement here? Because the last thing, to the chair's point, that we don't want to do is businesses look to Maryland as a place that is quote unquote anti-business, right? We have to get to a place where we're both the party of business and the party of workers, right? And so are there states that are doing this, or are folks going to look at Maryland in a separate way?
There are plenty. There's Minnesota, Illinois, and more. The interesting thing about Minnesota and Illinois, just late last year, the Department of Labor invited some other states to come, hey, tell us about your experiences and how you're doing so well. And guess who showed up? Minnesota and Illinois. Yeah. And they testified that, hey, they presented one of the reasons why we're doing so well is not only the DOL, but the AG's got authority too. And there are other states as well that I miss. You've got
wait, right here.
You got California, New York, Massachusetts, the District of Columbia, Illinois, Minnesota. We'll get that to you in writing.
Great,
this is not new, uncharted territory.
Appreciate it. Thank you, Mr. Chair.
Mr. AG, I was just reading along, it's a little confusion here. On your bill, because we are talking about Department of Labor, it says that the commission may not submit an application under the subsection unless the submission is approved by the Attorney General. And later on, it says similar that the commission may not file a complaint to enforce a subpoena unless these things are approved by the Attorney General. Now, I don't believe that's current law, so.
Sure. So, so the bill, and to be clear, right now, I believe the Commissioner of Labor can issue a subpoena without the approval of the Attorney General. However, there are other places in the law where, so it's, there, I think under Mosh law and a couple of other places under the Labor and Employment article where, the Labor Commissioner has to get the approval of the Attorney General to issue that. And I also don't,
I just don't understand why, it sounds like you said you don't want to take over the Department of Labor's job, but then you're like, yeah, but we want to make sure they come to us. Versus right now, they do have the independent authority to do these things. So it looks suspect. I don't know another word for it, but it's like, yeah.
I believe you're only talking about subpoenas and search warrants or something else?
Yes.
Okay. So as I said, right now, I believe the Labor Commissioner can issue a subpoena without the explicit approval of the Attorney General.
Right.
I don't believe the Labor Commissioner at this point can get a search warrant at all.
I'm sorry?
At this point, I don't believe that, at least in the context of the misclassification law, that the Labor Commissioner can get a search warrant at all. You can correct me if I'm wrong. There are other situations where she can, I know under Mosh, and in those instances, the Attorney General has to sign off on it. I also don't think that this is the heart of what's important in this law.
All right, Delegate Valderrama.
Thank you, Mr. Chairman. Mr. AG, good to see you. Welcome back to Judiciary. No one got that? Okay. Ha, ha, ha. Well, former Judiciary.
Doesn't it feel like that?
Yes. With that said, based on all of the debate that has gone forth and conversations prior to this hearing, it's my understanding that DOL has some consternation regarding dual authority between employers and employees. So what would be your response to that?
So they're going to come up and testify. And look, I want to say that we've had really, really good conversations with the Department of Labor. And I think what you're going to hear is the vast majority of the bill they support. It's the concurrent authority that they don't support. They have some good ideas about alternatives to this current authority that I think are worth considering. I'm going to let them introduce that when, if they choose to do when they testify. Instead of the concurrent authority that we lay out in the bill, they've got some other ideas like mandatory referrals. And again, the point is that none of the issues that will be raised are issues that, certainly not by the Department of Labor, are issues that cannot be resolved in amendments. We've done our level best. The bill that you see today is a lot different than what we had drafted in October, November. Why? Because of the positive input from the Department of Labor. So they've got they continue to have some concerns with it, and I believe that we can work it through in amendments. And it is around concurrent jurisdiction, whereas, that is the primary concern that you'll hear from the Department of Labor. And there are related concerns to that are throughout the bill, but they can all be addressed through amendments. We don't profess to we did not bring a perfect bill.
Right. Okay, I was going to follow up with if there was input, but you just answered my second question. So thank you very much.
Thank you, Mr. Chairman. So let me just say, I'm shocked and stunned by this testimony. I had to hear it. I'm a business that's regulated by the Department of Labor on this subject. They are one of the strongest enforcement arms in the state of Maryland. Pick a department under the governor and pick one that's stronger or more capable of making life difficult for bad actors than the Department of Labor. It's them. And so I had to hear what your position was on this. I'm not surprised that there's politics that's coming to the committee, because I think there's politics to this issue. I hope by the time we're done that we remove the politics and we start talking about the policy and how we grow our state and our economy at the same time, create level playing fields. That's a statement. And let me just say the first question I'm going to ask, and Mr. Howard, you were the Secretary of the Department of Labor, or an interim secretary. When did you serve our state?
I was appointed in 2012.
In 2012, and then you served through the balance of the maladministration. Okay, so, and you're the lieutenant governor during that same time frame. During 2014, okay, Workplace Fraud Unit conducted, after 102 complaints, 806 cases were opened. Okay, and of those 806, 660 were closed. And of those remaining, 101 received a citation, of which penalties were collected $89,000 and then fines $34,000 for the year 2014. And then in 2013, 1,272 cases were opened. 977 of those were closed, including mine, by the way. Number of citations issued, 155. The amount of penalties collected for the year 2013, 22,000. Fines collected, 17,000. I don't need your apology. I've served for 11 years and fought for small business issues, but I'll tell you that under your administration, people that worked in the Department of Labor, as I was fighting our state on this and later decided to run because of it, said that the department, okay, the administration was drunk with power, okay, using the authorities that were in front of them to go after businesses like mine to collect money. The state was in a tough financial spot. This is how we were going to help resolve those issues. And Commissioner Ron DeJulius literally said to me at the heel of cleaning up that mess that they left at my front door, that it was the wild, wild west. You had people that were trying to go after businesses without any consideration for who they were going after. So there was balance. So there was consideration for both sides. And my first question is, either one can answer it, is am I going to expect a better outcome, better percentages of success than what I saw under both of your leadership back when the Department of Labor was doing this 12 years ago, 13 years ago?
That was a hard question to follow.
I hope so.
And you missed 8 years, okay, when the department was almost completely inactive. And you also, in your question, you impugned the department and the men and women who work there. So I can't accept that as a premise to answering your question, because I think they're noble public servants who do their level best. The numbers speak for themselves. The numbers went down, okay, at the Department of Labor in terms of enforcement. They are beginning to tick back up, and they are not adequate in terms of protecting Maryland workers.
Mr. Howard, you want to respond to that?
Well, I'll just say that in no way was ever politics injected into any of the actions.
So the question
entire
was,
objective-
I believe his question was,
is there going to be a better outcome?
as far as percentages of complaints, investigations, and outcomes. I believe that's what he's asking.
Yes.
He's demonstrating by giving you the numbers of the complaints and how few of those complaints actually came with good with findings that would support the need to continue doing it. That's, I think, his question.
So, Mr. Chairman, so there are a lot of components to the bill, right? And I'm going to move away on the concurrent jurisdiction piece. The parts of the bill, as Ms. Heilman testified to, and I think you're going to hear more detail from the Department of Labor on those components, those are going to give the Department of Labor, not the Attorney General, they're going to give the Department of Labor a much more streamlined process and more robust tools. So even if you don't pass the concurrent jurisdiction, which I hope you do, but even if you don't, please pass the bill, because the Department of Labor, if I didn't have concurrent jurisdiction in this bill, the Department of Labor would be sitting right next to me testifying on behalf of this bill, okay? And because they want more tools, they need more tools. They were gutted and devastated during the last 8 years. Okay, that's not a political statement, it's just a fact. And the administration is investing more. I think the chairman said 5 additional investigators with the support of the General Assembly. They need these additional tools. So even if you don't give it to the Office of the Attorney General, you should pass the other parts of the bill.
Okay, I'm sorry. So I'm not getting the answer, but I'll assume that the answer is that the success rate here with equal or frankly substantial authority, more than what you're asking for at the time, and I'll explain in a minute, that the statistics don't bear out the point that you're trying to make, which is the Department of Labor can't do their job, and that's where I have a rub. So let me just ask, I guess the next question, which is, under the bill, do we still have the rebuttable presumption? Does that still exist as it relates to when you come to a business like mine? So there's the ABC test, and the ABC test can be overcome through the lens of a rebuttable presumption. Okay, does that?
Yes, correct. So we do start with the assumption that a worker is an employee unless they meet the prongs of the
So not to
ABC test.
impugn anybody, but I'll tell you how it worked in practice. Is it because there's the rebuttable presumption? Here's what an investigation looked like. You show up at a business and you say to them, you're in violation of 52 counts of the Workplace Fraud Act. All right, and you can get the honor of showing up at an administrative law judge and prove your innocence through the lens of the rebuttable presumption. Now, I'm not a lawyer, and I didn't stay at a Holiday Inn last night. But what I'd say to you is that when you have a department, and I think your bill, if it holds true that there's an ABC test with a rebuttable presumption, your investigations are not going to be thorough through the lens of showing up my door with a subpoena. It's going to be, I have a reasonable suspicion that you've done something wrong. Here's the citation. See ya when we see ya. Correct me if I'm wrong, because I have a follow-up to that. But that's the point of the rebuttable presumption, but go ahead.
He's asking, is it possible that you can, and I'm not trying to speak for you, I just want to make sure.
I lived it.
No, because we've heard this, that's why, I'm not trying to, I'm saying because he has actually lived this specific situation where they just kind of showed up with accusations, and now he's got to hire an attorney. Now he's got to jump through hoops, and I believe at the end he was successful.
Well, yes. Yeah.
But that's after a great expenditure, and I'm assuming a huge amount of stress. I think he's asking, is that the same thing that's going to be able to be done just to all businesses, not just those that were regulated by DOL currently?
Mr. Chairman, that is a difficult question to answer, and I say that only because I can't talk to someone's stress or things like that. You've given the Office of the Attorney General, you've given the Labor Commissioner, you've given the Department of Health, so many regulatory and oversight bodies the responsibility to protect the public. And when we do, does it generate stress? I can't speak to it, but I imagine it does. Are there times when government gets it wrong when they show up? I'm not going to sit here and tell you that they don't. Okay, I'm not going to do that. I'm saying if we got to build in protections in the law that aren't in the law, then let's do that.
Okay, the answer to the question is the rebuttable presumption still exists. Now, what I have heard a lot of people say about the rebuttable presumption is that when you add that with the ABC test, which is a three-prong test that you must pass all three prongs of those tests to pass, that in effect, it is a presumption within a presumption. We presume, state of Maryland, and if you get your bill, Attorney General, that you're guilty of the charge, but we're going to give you the courtesy of proving your innocence, not through evidence, but rather through the lens of pass my test that is almost impossible to pass through the lens of independent contractor relationship. So when I say a presumption within a presumption, it's one thing when you have the Department of Labor that has come in and they've made a determination, because I think for the most part, especially under the Hogan administration, their goal was compliance, bring you into compliance. Okay, we don't want to run you out of business. We want you to do what's right by the law. What you're doing is in respect, okay? And this is not impugning anybody. This borderlines on politics. Either we need the money or we've decided as a state that the Attorney General is going to go after the independent contractor business model as a whole. And I know this because the rebuttable presumption with a test that's almost impossible to pass can only lead to one conclusion, and that is you win. And that's not a comfortable place for me to be. Do you disagree on that principle?
So we're not changing the law on, as you mentioned, we're not changing the law on the rebuttable presumption, the ABC test. And just to clarify, right now, the Office of the Attorney General isn't doing anything because we don't have the authority.
All right. So let me just say the safe harbor that the chairman was talking about, and this is a question. Mm-hmm. Sure. If you came to a business, and you said, produce for me a written contract signed between the employer and the business entity that, one, describes the nature of the work to be performed, two, describes how you're going to get paid for that work, and that documentation also includes acknowledgement by the business entity that they withhold, report, and remit payroll taxes, pay unemployment insurance taxes, maintain workers' compensation insurance, and that this independent contractor also signs an affidavit that indicates that the business is an independent contractor who's available to work for other businesses, that they produce a current certificate of status for the business entity issued by the State Department of Assessment and Taxation that indicates the business is in good standing, and that proof that the business holds all occupational licenses required by the state and local authorities for the work to be performed. Would you walk away?
If that complies with the law, then we would.
That's the safe harbor. Okay, that you get rid of in your bill.
And look, if we want to work with the committee, if you think that provision in the bill doesn't work and you don't want to change that policy, let's work with that.
Okay, I'm going to close by saying this. It was not my intention to impugn anybody in this conversation. I will say that I'm a one-trick pony here in Annapolis. I'm a business guy that got affected by this, and for me to say that I respect the Department of Labor and the people that run it, it's because I, like a business owner, would want to have a level playing field. I would want equity in the workplace for the safety of our workers. What I don't want is to wake up one Monday and wonder, am I in violation of some law that could put me out of business? That's what your bill does. It threatens my ability to work confidently, to know what the rules of the road are, to keep bright line, clear paths to compliance with the law. Your bill violates basic principles of good business practice from government, signaling to business owners how to work in our state. And my apologies for going over the top at the beginning. It is personal for me, but it's only because I'm a business guy trying to make it, okay?
And again, Chris, I wasn't trying to cut you off. I know you've been through this before. We definitely understand, so we appreciate your input. And Delegate Wivel?
Thank you, Mr. Speaker. A.G. Brown, I just have two easy questions for you. One, I heard you say that you weren't asking for more money or PINs right now, but as the state's fiscal outlook improves, you most likely would. As I recall, your department was awarded PINs and funding some years ago to basically bring lawfare against the federal government. Is that funding still within your budget?
Let me say that a few years ago, the agency was not given additional funding, nor were they given funds. My predecessor essentially created from within the unit that you're talking
So as
about.
I recall, that bill passed the House, so it didn't pass the Senate.
No, 2017?
I don't remember what.
No, it did, but unfortunately, the legislature passed a bill saying that the governor will put money into the budget for, I think, 6 positions, and what the governor did was he put it in here and took it out here.
So
That's a net zero.
So it wasn't funded.
Right.
Okay. And then the other question, so does the bill allow recovery of attorney's fees from the state of Maryland by a defendant who is successful against the AG actions?
This bill?
Yes.
No, I didn't follow the question, but Ms. Hyman followed that
In
question.
other words, could somebody get attorney's fees from us?
So if someone's successful in your actions against that business, does that business have the ability to recover
No.
attorney's fees?
No.
Because they're, as you know, pretty high, potentially. Okay, thank you.
General Brown, understanding that you used to serve on Economic Matters Committee, I want to welcome you back to the kindler, gentler Economic Matters Committee.
This is reminding me of my years on Judiciary Committee.
But my question for you is, looking at some of the opposition testimony, have you considered, and I know with respect to the chambers, there's some concern about the penalties and the level of the penalties. Is that something that you'd be willing to work with some of the folks that are in opposition to try to, make those more amenable?
There is not a provision in this bill, and this is not like a desperation, like, oh, please pass anything. But again, it's a 43, I think, plus page bill. And there's not a provision in the bill that we are not willing to work with the committee, the stakeholders, and find common ground. There are going to be parts of the bill you're going to look at and say, take it out. It might be penalty provisions, say, take it out. We put it in there because we think this is a good assortment of tools, again, not just for the AG, but for the Department of Labor, to be able to protect workers. So we're willing to work with the committee on making the adjustments, the amendments as necessary to get a workable product.
Thank you, Mr. Chair.
Thank you, Mr. Chair. Welcome. I have a couple quick ones for you. How many businesses did you involve in this process? This is your bill. This is what you all came up with. How many actual businesses were involved with you in helping you generate this?
We met with the Chamber of Commerce. We know that you, as members of the General Assembly, that you want us, before we bring something to you, talk to the stakeholders. So we met with the Chamber of Commerce. We showed them the bill. They explained to us some of the concerns that they had with the bill. And I don't know how many, if any, we addressed in the bill, but the answer to your question is we did engage the business community.
But no real businesses. You've never met with owners of businesses
I mean,
and stuff.
you're going to have the chamber testifying here. I think that
I know, but
they
as you
represent
said, these are the
businesses.
people that are going to talk about it. I guess I'm a little surprised, and the chairman brought this up, you do work for business and labor.
I do.
Yes, you do.
Yes, absolutely.
Yeah, we all do, actually, so keeping that in mind. But I'm a little surprised that we're bringing stuff up to you that was not brought up to you in the past, and you're willing to negotiate that, but I would think if you were including them in this, because this bill, you know, with warrantless searches, I can only imagine if you'd reverse this and say me as a business owner would tell you, you know what, AG, I got a real problem with this guy over here, he's stealing off me. If you would then give the same opportunity going in this, knocking on his door and say, hey, this guy has a problem with you, I'm gonna do a warrantless search, I'm gonna find everything. You wouldn't be good with that, would you?
Actually, I don't think I was clear in answering your last question. Not only did we sit down with stakeholders, but we invited them to send us any proposed amendments to the bill and didn't receive any proposed amendments.
Okay.
So we're always willing and open to.
How about the second question?
Can you repeat that question? I apologize.
Okay, turn it around. Let's
Yeah.
say I'm the business and I have a problem with an employee. And I come to you and say, I got this guy that works for me or this person that works for me, and I got a problem with him. Here's my complaint. Are you okay with going up and knocking on his door and saying, I got a complaint about you, I'm coming into your house, I'm going to do a search of everything?
The General Assembly hasn't given me the authority to do that.
Would you do it?
I don't have the authority to do it.
Would you do it?
I don't have the authority. I can't tell you I do not have the authority. I am a creature, the Office of the Attorney General is a creature of the Maryland Constitution and statute.
Okay, so then you're saying the General Assembly, you want them to give you authority to do a warrantless search into a business?
I mean.
And you're okay with that as a?
I'm asking for greater tools to protect workers.
Okay. Okay.
And if there are provisions of the bill that you think are over the top.
I guess my point is I'm surprised that you brought this bill with something like that without thinking about it from the other side, because that's your job.
We spoke to the other side, Delegate. We did. And we asked them to give us amendments, and they did.
They were okay with this?
No.
Oh,
no, they did. No. I'm not representing that this is a compromise bill with the other side. No.
I'm just saying.
We showed it to them. They said they didn't like it.
Regardless of what they say, you are representing both sides. You have to, right?
Yeah.
Well, why would you permit that? I mean, you're saying you're okay on one end, but you're saying I have to give the authority on the other end.
Let's work through the bill. Let's find the balance, and let's pass a strong bill.
Okay, would you like to word that other piece in, where you could do a warrantless search in my house? Would that be okay if we could put that?
That's probably beyond the single subject rule.
Okay, thank you. I appreciate the answer.
All right. Nobody's probably happier to see me chairing the committee than you. I don't know what is going on, but I hope you guys all work it out. With that, that concludes this panel. Thank you, Mr. Attorney General. Next, we will go to the favorables.
Thank you, Mr. Chair.
Terry Kavanaugh, Megan McDermott, Mario Murcia, Paul Pendergrast, and Bill Kress.
That's it. I'll stay for a little while.
All right, very good. I think I can be heard here. I'm Francisco Romero. I'm going to be speaking on behalf of 32BJ today. And,
Who are you here? Sorry, sir?
They sent in the name for Mario Murcia, so but they changed name, so I'm going to be speaking.
Sir, you can't do that. You have to sign up. For you to testify, your name has to be signed up for public record. So I apologize. Unless you're signed up someplace else. What is your name?
Francisco Romero. Mm-hmm.
Sir, you're not here. I apologize.
Okay,
We'll
no
go to
problem.
the next.
Mario Murcia, he's here, so he can go ahead and do it.
Well, then why didn't he come up? What is going on here?
They changed. It's all right. Go ahead. We have a strong argument.
Okay. Whoever's next, please start.
I'll start. Good afternoon to the committee. My name is Megan McDermott, and I'm an advocacy director at Maryland Legal Aid. House Bill 1096 recommends expansive new safeguards to ensure workplace fairness and safety. All Marylanders deserve fair pay and a safe place to work. Low-income workers, like the clients my colleagues and I represent in Maryland Legal Aid, are especially vulnerable to workplace fraud, wage theft, and poor working conditions. Worker misclassification and wage theft are major issues for our clients. Many legal aid clients work in the gig economy, an industry notorious for hiring workers as independent contractors with promises of flexible schedules and autonomy, when in reality these jobs are highly controlled by the employer, and these individuals are really working as employees. Other legal aid clients work in unseen, low-paying jobs such as maintenance, cleaning, or farm work. Just as these workers often go unnoticed, so too do their working conditions. This bill has real teeth. It not only provides clearer standards around misclassification and wage theft, but articulates clear penalties and enforcement mechanisms that will hold employers accountable and help ensure workers are actually protected. Low-income people do not have a financial safety net, so the streamlined investigations and direct restitution in the bill are critical to guarantee workers are not further harmed. Legal aid receives many requests for representation in employment law. So many, in fact, that we joined the Office of the Attorney General and its plans to expand legal advocacy in this area. While OAG may be bound by the passage of this bill, legal aid is moving forward now with creating a workers' rights unit and will begin to expand its practice in employment law by representing clients in wage claims, worker misclassification, and workplace safety in 2025. Maryland Legal Aid urges a favorable report on House Bill 1096. Thank you.
Thank you, Chair, and thank you, Attorney General Brown, for bringing this bill forward. My name is Paul Prendergast. I'm an attorney in the Labor Compliance Department of the Eastern Atlantic States Regional Council of Carpenters, representing carpenters, millwrights, floor layers, and pile drivers here in Maryland. Our union strives to ensure fair working conditions and wages for our members throughout Maryland. With those goals in mind, the union promotes legislative efforts providing for stronger enforcement of labor laws, preventing unscrupulous contractors from cheating workers, and utilizing illegal methods to drive down costs in the pursuit of construction opportunities. Which brings me here today in support of House Bill 1096. This bill goes a long way toward protecting workers and leveling the playing field in the construction industry. Under current law, the Attorney General does not have the statutory authority to directly enforce wage laws, leaving an enforcement gap that allows unscrupulous employers to evade responsibility. This failure to properly enforce labor laws enables tax fraud, unemployment insurance fraud, workers' compensation fraud, and other forms of exploitation that harm both workers and taxpayers. An important provision of this bill that I'd like to highlight concerns misclassification. In the course of our efforts, I have met with workers here in Maryland who are misclassified as employees of a labor broker. When it was time to collect their wages, the labor broker refused. Through collective action, those workers were able to secure payment from the general contractor. However, such courage and coordination by workers should not be required simply to receive a paycheck for an honest day's work. By supporting this bill, you can help ensure that if a worker shows up and does their job, they'll be paid as promised. House Bill 1096 addresses such problems by making higher-tiered contractors liable for misclassification by their subs. This is both an effective and sensible policy. A general contractor benefits from a subcontractor's violation of labor laws. Through misclassification and wage theft, the lower cost of subcontractors creates a more competitive bid for general contractors and increases their business opportunities. On behalf of union carpenters, I ask you to support this bill and stand with the working people of Maryland. Thank you for your time and consideration.
Thank you for the opportunity to testify today. My name is Mario Murcia. I'm a political staff. Francisco Romero is an elected executive board member, but I'm happy to give this testimony. 32BJ SEIU is a union that represents janitors, security officers, and airport workers. 32BJ has 10,000 members who work or live in Maryland. I would like to highlight one janitorial contractor, CVVY Enterprises, to show how misclassification hurts workers. CVVY currently cleans 7 sites in Baltimore, including 3 where it recently displaced a law-abiding union contractor. 2 of these buildings house state offices, the Department of Labor and the Department of Information Technology, and the Office of the Public Defender. Before CVVY took over from a union contractor, workers could depend on annual wage increases, employer-paid health insurance, paid time off, and job security. All that changed when CVVY took over. CVVY initially refused to hire many of the workers and told them that they would be rehired only as independent contractors rather than employees, even though the job duties had not changed. The union has already filed claims under the city's Displaced Workers Protection Law and the National Labor Relations Board for the company's refusal to offer employment to union workers. At the building where DOL has its offices, CVY is now paying workers as 1099 employees, 1099s, even though they are clearly legally employees. They work at the direction of CVY supervisors. They're paid hourly. They are given clear schedules of tasks, and CVUI provides their equipment and uniforms. At the building where the Office of Public Defender has offices, CVUI eventually hired some of the 32BJ employees, but has not given them notice of their pay rate and schedule and hasn't consistently provided pay stubs. This has made it hard for workers to understand their employment status and made their actual wages, or know what their actual wages are. We also believe that company doesn't have a workers' compensation policy. 32BJ is preparing to file a complaint.
Sir, we need you to start wrapping it up.
I'll wrap it up. And unfortunately, the consequences of misclassification under the current law are just too low and discourage companies from breaking the law. This is very true for janitorial contractors because they gain.
Thank you, sir.
Sorry. Thank you.
Go ahead, Terry.
Thank you.
Good afternoon. Terry Kavanaugh on behalf of SEIU Local 500, Vice Chair Crosby, members of the Economic Matters Committee. Just want to say a few things. Local 500 represents about 23,000 workers and ask for your support on their behalf for the support of House Bill 1096. The bill is crucial in ensuring fair labor standards, enhancing worker protections, and holding bad actors accountable. 1096 strengthens the Maryland False Claims Act by expanding its scope to include fraudulent underpayments of unemployment insurance contributions and improper claims for benefits. This provision is essential to maintaining the integrity of our unemployment insurance system and preventing fraud that harms both workers and taxpayers. Additionally, the bill enhances enforcement of wage and hour laws by providing the Attorney General with expanded authority to pursue claims on behalf of workers when widespread violations occur. It also introduces stricter penalties for employers that knowingly misclassify employees as independent contractors, a practice that deprives workers of essential benefits and protections while undermining law-abiding businesses. To finish, I'd say the bill mandates that civil penalties and damages collected for violations of prevailing wage laws be directed towards restitution for affected workers. This provision ensures that workers who have been wronged are compensated fairly and expedites financial relief for those impacted by wage violations. You know, there's been a lot of talk about waste, fraud, and abuse. This is an opportunity for a bipartisan approach to dealing with the fraud that is out there. The Attorney General laid out a case for what's happened already in Washington, D.C. in a judgment. We can do the same here. Thank you.
Seeing no questions, that concludes this panel. Next, we will go to Amy Galatly, Greg Leonard, Donna Edwards, and Roger Mano. Star one ready. Go ahead. And I apologize if I butchered the name.
That was pretty close. Good afternoon, members of the committee. My name is Amy Galatly, and I'm here from the Public Justice Center to testify in support of House Bill 1096. I think I will cut right to two examples from our work in the last year that demonstrate the continued prevalence of workplace fraud in Maryland outside of the construction and landscaping industries. The first example is from a call center. We spoke with a worker who told us that as a condition of employment, she had to sign an agreement informing her that she was an independent contractor, but nothing about her work actually resembled that of an independent contractor. Instead, the call center meticulously managed every detail of how she did her job. It told her what hours to make the calls, who to call, and it gave her scripts for exactly what to say while she was on these calls. She was paid between $2 to $5 per call, and it didn't matter how long the call lasted, and she wasn't paid anything at all for hours she spent on the phone if nobody answered. She was clearly being misclassified because that employer had control over every term and condition of her work. The second example is from an assisted living facility. We spoke with 4 employees of this assisted living facility who had worked 24-hour shifts for which they were paid only $80 a shift, which comes down to less than $4 per hour. And they were being paid through a payment app where they didn't receive overtime and the employer did not deduct payroll taxes or any other sort of taxes on their behalf. These are telltale signs that an employer is engaging in workplace fraud, whether they know that's what it's called or not, trying to pay people under the table and not pay taxes that they owe to the state. These are, again, a clear example of workers who are not running their own business, do not have control over the terms and conditions, and are doing the work that the employer has set up as their own course of business. For these reasons, we urge a favorable report on HB 1096. Thank you.
I'm going to have Roger go, please, sir. Thank you.
Thank you, Mr. Vice Chairman, members of the committee. Roger Mano on behalf of a consortium of construction trades unions, the carpenters, the iron workers, the UA, represented by the Mid-Atlantic Pipe Trades Association, and some 200 contractors represented by the Mechanical Contractors Association of Metro Washington. You have my written testimony. I'll associate my comments with the Attorney General's comments. We support this bill. We think that concurrent jurisdiction is greatly needed in the state of Maryland, where wage theft, according to recent reports, runs rampant, and we'd ask for a favorable report.
Thank you. I'm Donna Edwards. I'm president of the Maryland State and DC AFL-CIO. We are here in strong support of HB 1096. We believe that this is an important tool in the legal toolbox to capture millions of lost Maryland revenue in unemployment and workers' compensation and in business taxes. I have changed my testimony since listening to that in the beginning. I want to say that I have great respect for the good businesses that I know people are running that sit on this committee, and we've worked in previous years to come to agreement or at least make it palatable, and I hope we do that. But the governor reestablished the Joint Enforcement Task Force on Workplace Fraud. And during that, there's 2 things in there. Combating the practices effectively requires a whole of government approach involving multiple different agencies and authority with state government. And the state's enforcement efforts can be enhanced further and made more efficient through interagency cooperation, information, and joint prosecution of serious violators. We have the importance of this legislation is the expanded collaboration between the Department of Labor and the Attorney General and providing this legal tool as we see it. We will not improve the economy of Maryland by protecting bad actors who are making their profits and sustaining their businesses by cheating workers and by cheating the state of Maryland of millions from UI, workers' compensation, and taxes. This bill is important. It puts us in line with what nationally is going on state by state. It puts us in line with our neighbor next door when many contractors that we have, many businesses do business in Maryland and DC, and they know what is required of them, and we know that you do not want to protect bad businesses. So please pass HB 1096. Thank you.
Thank you, Donna. Seeing no questions for this panel, we will now go to the unfavorables. But before that, Delia McComas, I got you 5 bills away. So if you want to go, we can reach out to your office, or you can continue to watch the fireworks, your call.
Thank you.
Okay. I guess this beats judiciary, huh? All right. So next we'll go to the unfavorables. I have Chad Horrell, Margaret Durkin, Michelle Blackwell, Grayson Wiggins, Mike O'Halloran. And I don't see Mike. I know he was in E&T. So Sean Malone, you can start when ready. What? No. Sean Malone. Go ahead, whenever ready.
Good afternoon, Vice Chair Crosby and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director for TechNet, a tech trade association. Thank you for allowing me the opportunity to speak today on House Bill 1096. The composition of the U.S. workforce is changing, and due to the availability of the gig and sharing economies, the independent workforce has grown to serve as an important source of supplemental income to millions of Americans. TechNet understands the intent to combat any type of employment fraud. However, we are concerned that House Bill 1096 creates a presumption for traditional employment without regard for independent contracting work. We believe that the terms in this bill conflate the traditional worker with independent contractors, such as the definition of worker. And we believe that the exemptions in the employer-employee section are overly broad and subject to many different interpretations. Government requests for data need to consider consumer protection, business innovation, trade secrets, and privacy. Complaints to the Commissioner and the Attorney General in this bill raise concerns about the requirements for businesses to provide records on books, registers, et cetera, as well as any other records relating to compliance. We believe that this will potentially reveal companies' trade secrets and intellectual property. Furthermore, determining one's identity and worker activities is anti-privacy in our view. We believe this is not the right approach to combat employee fraud, and for the above stated reasons, we're opposed to House Bill 1096. Thank you.
Good afternoon, members of the committee. My name is Chad Horrell, and I'm with DoorDash. DoorDash is a third-party delivery company, and our delivery drivers are, we call them dashers. Who are these dashers? In Maryland alone, there are 220,000 dashers. They come from all walks of life, from teachers to students, caregivers, pastors, retirees. 60% of them are women. Dashers work on average 3.4 hours per week on the platform. They earn $24 per active hour in Maryland on the platform. DoorDash opposes HB 1096 because it imposes sweeping changes to how Maryland has traditionally defined employment under the state's wage and hour laws. Dashers are currently independent contractors and come to this work because of the flexibility that this work provides with that status. But they could be reclassified if HB 1096 were passed, stripping these dashers of the flexibility that they come to the work for. When the average person thinks of employment, they usually think of a time when you have to show up 9 a.m., clock out at 5. They're usually tasked with a number of projects by their employer. This is not how dashers work when they come to the platform. Dashers do not clock in and clock out at any specified time. They have the ability to accept or decline the orders based on their choice. Some of them can opt to make one delivery and head on their day, get on with their day. Some could do it for multiple hours and get paid more for that. It's entirely up to them. 81% of dashers already have full or part-time jobs. They dash to supplement their income, to earn income for an upcoming event, like say beginning of school, they need to get school supplies, pay for a vacation or a birthday party. Some, like caregivers, can't work a traditional 9-to-5 job and come to this because of the flexibility that it provides. 91% of dashers prefer the flexibility of dashing, and this is why we ask you to oppose HB 1096.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. I'm going to start with a question that we can't seem to get answered, and that is that the Attorney General is telling you he's not changing the ABC test, but the statute is being changed and language is being inserted into the test in addition to exemptions and exception language being removed in the current statute. That's important because there are multiple tests for what is an independent contractor or an employee. You have the wage and hour law, which has the economic realities test. You have the workers' comp law, which uses the common law test used by the IRS. And then you have the UI ABC test, which is the same as the WFA test, the workplace fraud test, but they didn't change the test in the UI statute to match this. So they're actually creating now a fourth test, and then they're trying to apply that to every industry in the state. That's problematic because the UI statute has a delineated list of exceptions. The workers' comp statute has a delineated list of exceptions. And so they're going to be applying this not only across the board, but to new industries who have not been subject to this before. And as Mr. Horowitz pointed out, that's going to upend business models and upend the way that businesses practice in the state that have not been subject to this, that are delineated as exempted from the statute. It's additionally problematic because the term general contractor is defined so broadly in the bill and coupled with joint liability that this is going to cover any project that's outsourced. Not the traditional construction project, but any project that's outsourced by any business in the state, whether they're on-site or off-site, and then it's going to apply that liability up the chain to the general contractor. That is going to be untenable for businesses. It's not a workable model, and it creates a compounding amount of issues. In addition to that, as was previously mentioned by the chair, we have concerns with the warrant language, the warrantless search language in the bill, and how businesses will be accessed during their time of work or potentially not during their time of work, and the information that could be uncovered. I don't know how that would be used. I do want to just quickly state we are all for people being classified correctly. We're all for compliance. But this bill is unworkable the way it's modeled. And just last point, Mr. Chair, I promise, the statutory framework has always been about compliance. There are references to the adjudicating person making sure they don't over-penalize an unknowing actor. He actually sets forth minimum penalties in this bill for unknowing actors, which is problematic too. Thank you.
Good afternoon. My name is Michelle Blackwell, and I'm a Senior Public Policy Manager for Uber. Thank you for giving me the opportunity to speak today on HB 1096 and its impact on Marylanders. My testimony today will focus only on one part of the bill, the definition of worker. Despite the laudable and intended goal of disincentivizing fraud in the workplace and protecting vulnerable workers, HB 1096 has the potential to completely upend the flexibility of platform work and shift the way thousands of Marylanders are earning a living. The bill's proposed language to who is considered a worker could fundamentally change how people work and earn because it presumes that all workers are employees unless proven otherwise. This significant change to how workers are classified does not contemplate or consider those who do choose to operate as independent contractors. Currently, the independent contractor status in Maryland allows for those engaged in platform work to freely choose when and where they want to work. In fact, in Maryland, nearly 80% of the drivers on our platform drive less than 30 hours a week, and 90% of our couriers deliver food less than 30 hours a week. This means that Marylanders are determining how to use their time without the burden of a set schedule. Additionally, HB 1096, Additionally, HB 1096's ABC classification test would make Maryland one of the most challenging states in the country for platform workers and other ICs who wish to maintain their independence. In order to protect the current structure in Maryland and the flexibility of platform work, HB 1096 should be amended to remove the presumption of employment and, more importantly, provide an exception for those who are engaged in platform work. I'd also like to briefly respond to the notion that Uber is losing across the country. There is no state where platform workers are full-time employees. I believe the AG was referring to settlement agreements that we have entered into with some of his colleagues. These settlements were entered in and done through collaboration with those offices, and now those platform workers have access to benefits and their flexibility. Thank you.
Good afternoon, Mr. Chair, members of the Economic Matters Committee. 16 years ago, I'm testifying on behalf of the Maryland Minority Contractors. 16 years ago, the Maryland Minority Contractors sat down with Secretary Perez, and we helped draft this bill. And we came and we testified in support of this bill because misclassification impacts our ability to bid properly. And employee brokers are not welcome on job sites that we're on. The current law works. It worked under Secretary Howe when he enforced it. The issue is under Governor Hogan, they did not coordinate, but they are now coordinating. And just on Friday, a report put forth from the Secretary of Labor that indicated in working with the AG's office, they are starting to make some of these cases. The law is fine. The law works, but the executive branch has to enforce it and work with it. I take issue with the idea that this test is not being changed. Let me be clear. This is a massive rewrite of this bill. A bill that was worked on hard and was actually mimicked in large portions in DC and in Delaware. Taking out an exempt person from the test, that is a significant issue because there are workers who work with their own tools, their own truck. They are not under the direction of anybody. And we're taking them out of this economy by this bill. We can't put them on a job site under this bill. I think the other issue of concern is literally this bill is supposed to draw a distinction between the general contractor and the subcontractor. The subcontractor works independently. But in this bill, as it's drafted, the general contractor is presumed to be the employer of all employees on the job site. So you're now saying to the general contractor, get into the business operations of smaller subs and make sure they're complying with law, or we'll hold you jointly in several liability. That's not independent control. It's eroding it. This is a poorly drafted bill. We urge your opposition.
Real quick. So many years ago, I came through and I had somebody say, this is editorial, didn't even respond to it, that the #1 violator of the Workplace Fraud Act is the state because we hire so many state contractors. As of last year, 2,746 plus 2,086 contractual employment arrangements the state of Maryland has through different departments. So one wonders if they're going to invite all industries to participate in this newfound law, whether they're including themselves in the subject. My question goes to entrepreneurship and small business ownership. We have sole proprietors, businesses that decide, people that decide one day, you know what, instead of working for somebody, I want to work for myself. Do you think a bill like this is going to have a chilling effect on those people that want to come out of the employment and work for themselves to make their own living? Do you believe this bill will violate that principle of American entrepreneurship that we so desire in our state and our country?
It takes away the exempt worker. I mean, it takes away a person who performs in their own personal capacity and the ability for, on our job sites, we may have someone who specializes as a carpenter. That's what they do. They got their truck, they got their tools, and they do a great job with railings. We hire them, they come on the job. They're paid as a 1099, and under the current law, we're required to advise them of all their obligations under the law and keep that affidavit, because what that does is it provides the labor commissioner proof that whoever that sub or independent contractor was that came on the job, they were fully aware of it, and they can take that affidavit and use it against the individual and say, you're aware of the laws, but you violate your actual employer broker. But yeah, but it literally scratches them out in red out of the law.
Thank you, Mr. Chair. This question is for Ms. Blackwell from Uber. Looking at your written testimony, I want to better understand what is not working in other states. We heard from Mr. Brown in regards to other states that are doing this. The Attorney General pointed out other states that are doing this well, et cetera, et cetera. But according to your written testimony, you state that in California, the similar bill has actually harmed the economy in negative ways. Just want to get a better idea, because I know we can deal with what could happen if this bill passes, et cetera. But I kind of want to get an idea of like what is happening in other states. What has been the result of legislation like this on the business community and impacting your industry specifically?
Thank you for the question. So in my written testimony, I specifically point to Assembly Bill 5 in California, which I think many people have heard about. And one of the things about that bill was that it forced everyone into the employee status. And the idea was that you would protect more people because they wouldn't have the option of being an IC. They're an employee. Now, they ended up, I think, exempting over 100 professions. But for those who were not exempt, there was this idea that you would see more people then enter into W-2 work. And what we have seen since then is that has actually not happened. We've actually seen people who are self-employed, we've seen those numbers drop. And so when you look at a test that is so restrictive, that sort of either just forces everyone into employment, the notion that people will then just become W-2 employees is not necessarily bear out.
And is there any analysis from some of the other states that were mentioned earlier today that where that is also taking place? I think the example is given where I think Minnesota and Illinois were doing well with this law. Do you have any context on what's happening there?
I don't. I'm not sure that I mentioned Minnesota.
I'm talking about the Attorney General did.
I don't know that it was pertaining to the law as opposed to the AG having some involvement in
Got it.
That, yeah, it didn't have anything to do with the test, I don't believe.
Got it. All right. Thank you. I appreciate it.
Okay, seeing no further questions, we now have Mike Adams, Lisa Jones, Well, that'll round out the unfavorables.
Hey, good afternoon, Mr. Chair, members of the committee. I'm Lisa Harris-Jones, and I'm here on behalf of DoorDash. I thought I'd be sitting next to him and also represent the Maryland Minority Contractors. I, too, was in the room actually a year before Mr. Malone, representing the minority contractors on the misclassification bill that, quite frankly, the law as it stands, if applied and enforced, is what the state needs to go after the bad actors. This bill is drafted a 43-page bill, 14-page fiscal note. I took about 2 days to get through the bill to figure out exactly what it would do. And it's so far-reaching that it's very similar. I heard the question about California, that not only did California have to, as it was shared, amend that legislation, that law twice. They actually had a referendum that passed by a 17-point margin that those that lived in California agreed that the way that the law was drafted, it should not at all have included gig workers. And I say that because it's very important, as was shared, that people want to have the opportunity to not be someone's employee. They want the opportunity to set their own hours. And this bill would pull them in. And it also would, as has been shared, which is very frightening, representing minority contractors who, at the time the original law was drafted, sat in a room with, as a minority of non-union, as a non-union worker, had to actually fight to get all of the amendments that were placed on that bill, so they didn't have to fear that someone's going to walk in and go through their documents and harass them. And with that, I ask for an unfavorable report.
Thank you, Mr. Chair and members of the committee. I will be, my name is Michael Adams on behalf of Associated Builders and Contractors. I will be brief because most of the territory has already been covered, but this bill does represent a vast expansion of state power to address a problem that is already being addressed by the Department of Labor and a private right of action. As to the construction industry specifically, this bill deletes the affidavit and safe harbor requirements that are in existing law while substituting a burden of joint and several liability on the general contractor. What does this mean in reality? This means that a general contractor in an industry that is admittedly already difficult to break into in many instances will be, by its very nature, less likely to subcontract with small up-and-coming businesses that maybe they don't have a track record with. Previously, you could bring on a new company and you could have them sign an affidavit, you could have them sign a contract, you could have them turn over all the necessary documents and be assured that they knew what the requirements were and that they would abide by them. By changing that dynamic, by making this completely on the general contractor, it sets up this inherent tension between generals and subs, which will only make it more difficult for small businesses, subcontractors to get work moving forward. I don't think that is what anyone in the state of Maryland wants to see moving forward, and I would urge an unfavorable report on this bill. Thank you.
Thank you both. Seeing no questions, that concludes this panel. Next, we will go to two informational witnesses, Secretary Wu and Commissioner Virk. You can start when ready, Madam Secretary.
Thank you, Mr. Chairman. And members of the committee, for the record, my name is Portia Wu. I'm Secretary of the Maryland Department of Labor. Thank you for this opportunity to provide informational testimony on House Bill 1096, and Commissioner Virk is also here to answer questions. The Department of Labor is dedicated to protecting Maryland's workers and ensuring compliance with our state's labor laws, and we thank the Attorney General for sharing that commitment. Under Commissioner Virk's leadership, the Department of Labor and Industry has prioritized and increased enforcement. Last fiscal year, the division recovered more than $1 million in unpaid prevailing wages, more than the previous 3 years combined, and we're on track to exceed that this year. Worker misclassification has real costs. The report of the Joint Enforcement Task Force on Workplace Fraud was already referenced, and there are costs for workers, for businesses, and for Maryland's economy. HB 1096 includes several provisions that are consistent with the recommendations from that task force report, including addressing joint liability and providing more meaningful consequences for violations of the law, as well as licensing, suspension, and disbarment for workplace fraud violations. However, the department has concerns that this legislation stands to create a duplicative investigation and enforcement regime to the department's authorities under existing law. It creates inconsistent tools and remedies, providing the Attorney General with new and expanded powers and remedies that would not apply when labor brings cases under the same laws, actually with assistant attorneys generals bringing those cases in court. This could create different outcomes for workers and businesses under the exact same laws. And some of these provisions, as was noted before, appear to limit the department's ability to use its existing authorities and powers. Particularly in this budget climate, we must rely on strong interagency collaboration. And the work that's been done under the umbrella of the Joint Enforcement Task Force already demonstrates that this collaboration can bear real fruit. One workplace fraud citation issued by the department and shared with sister agencies led to the discovery of over $1.7 million in unreported wages. We understand the concerns raised by the Attorney General, and we believe that the concern about making sure sufficient enforcement action takes place, regardless of the administration, could be addressed in other ways. For example, through a mandatory referral system between the AG's office and labor to increase visibility and ensure cases are reviewed promptly. Such a system would best leverage state resources and would protect and ensure consistent enforcement of the laws and to achieve fair and equitable outcomes for Maryland workers and businesses. The department looks forward to engaging with the committee and the Attorney General's office to address the issues. With that, we're happy to answer any questions.
I'm just here for information.
Moral support, got it. Delegate Chi.
Thank you, Mr. Chair, and welcome, Secretary Wu. It's always great to see you. So a couple of the colleagues raised a question, and I just heard your testimony. Can you just go back now that A.G. Brown is, I think, out of this room? No, that's not what I meant, okay? Come on, guys. I'm a much nicer and gentler version of ECM. But yes, I think there is some legitimate level of confusion about co-enforcement. And are you in favor of the idea of co-enforcement? And I know A.G. Brown's office technically is not part of the executive branch, right? But you collaborate in some cases. So could you just speak to that?
Let me open, and Commissioner Virk may wish to elaborate. I would say we support there being stronger tools to enforce the law. It's true there is a strong framework in place, but we've seen changes in industry, misclassification cropping up in different industries, and we do need stronger tools. That said, we're concerned about creating two sort of parallel roads that are not only about workplace fraud enforcement, but frankly about all forms of wage enforcement. And with that, you could have duplication and confusion. We do believe collaboration in enforcement is really the route that should be taken. Is that answering your question, Delegate Chi? I think.
Thank you. Do you do outreach engagement with the business community on the subject of classification, prevailing wage and hour law, and everything?
Yes, we do. Actually, as part of the Joint Enforcement Task Force, we actually had some sessions, for example, with small contractors, and some of the recommendations from that report, particularly trying to get at the question of general contractor liability, came from that discussion because some small contractors said to us, well, we can't bid if there isn't a level playing field because of low cost. It can lead to issues. That said, we believe that there's still a lot of work that needs to be done to get some more information from businesses, and absolutely take the point that was made earlier that it needs to be an ongoing dialogue. We need to hear that input. Commissioner Burke, I know we do in a variety of places. We also do just general compliance outreach, but.
Yeah, I mean, obviously happy to talk about the outreach work that we do. in other wage law and compliance arenas other than workplace fraud, which the Secretary already spoke to. We had two new laws come online in fall of last year, the pay stub transparency law and the wage range job posting law. We did extensive outreach, including a webinar that I think drew almost 2,000 attendees, most of whom were businesses, human resources professionals, and organizations. We've drafted and pushed out FAQs, both on those issues as well as generally on subjects ranging from how to participate in the prevailing wage survey, and push that out to businesses and contractors who I think were not really part of that community with whom we had previously engaged, and have done what we can so far to try to make our website more navigable by contractors, particularly on the prevailing wage FAQs and compliance direction there.
I would imagine some of the outreach normally leads to some businesses realizing, hey, I'm not doing it the way I'm supposed to be doing it. And that's the compliance part. That's the bring a company into compliance as opposed to the other option, which appears to be this bill, which is the heavy hand of government to be a dissuading factor for our used companies to be made as examples for you don't want to go through that same thing. So let me just ask the question in a different way. When you do these outreaches, is compliance part of the goal? In other words, we're giving the information, we want you to understand what's going on, but it's through the lens of doing it the right way, not necessarily to figure out how long you've been doing it the wrong way.
Of course. I mean, we can't conceivably visit every business and audit, nor would we audit all of their business and labor practices. We rely on businesses to obey the law. And in order to obey the law, businesses need to understand what the law is and how to comply with it. And we do see that as part of our role, yes.
Thank you for what you do.
Thank you. And just a note for everybody, the AG is back in the room for any further questions. It's a different set of questions when you leave. All right, seeing no further questions, that concludes this bill hearing. Next, we will go to House Bill 1162. Mr. Speaker Pro Tem, Delegate Stein. And Dan, I have Andrew Ozer, Doug Presley, and Sean Maloney.
So you see why there was some confusion with that, right? Didn't think my name was that common.
Thank you, Mr. Chairman, committee members. HB 1162 deals with the sale of HVACR equipment, heating, ventilation, air conditioning, refrigeration equipment. Specifically, it would require that distributors of HVACR equipment only sell that equipment to individuals who are legally authorized to install this type of equipment. And our licensing requirements in the state for installation of this equipment is a consumer protection practice. It ensures that consumers receive a safe, efficient, and high-quality installation. And there are dozens of complaints that are reported annually regarding HVACR services from unlicensed contractors. So requiring equipment sellers to follow license requirements will significantly improve compliance and benefit consumers in the state. My sponsor amendment strengthens compliance by making violations a misdemeanor consistent with existing penalties for license infractions. It also removes annual reporting requirements, which some had been concerned would be too burdensome for small businesses. The bill does retain the exceptions in existing license requirements, including allowing a building owner to install equipment on their own property. It also doesn't apply to small plug-in appliances such as window air conditioners and space heaters. And to reduce the impact on businesses, the bill exempts construction material suppliers and only applies to businesses that are conducting significant HVACR sales. And lastly, the bill does include a required disclosure from sellers to make sure that building owners and contractors who are purchasing this type of equipment are aware of the licensing requirements. With that, Mr. Chairman, I urge a favorable report.
Good afternoon, Vice Chair Crosby and the rest of the committee. My name is Sean Maloney, and I'm the current president of Heating and Air Conditioning Contractors of Maryland, a trade association for over 100 independent HVAC contractors, distributors, and associate members in the state. I'm also the president of SM Mechanical, a family-owned, full-service heating and cooling company based in Essex, Maryland. HACC strongly supports Bill 1162, as this legislation will help close a gap in existing law. Maryland currently has rigorous license requirements for HVAC contractors, which provide strong protections for consumers. However, unlicensed contractors may still buy HVAC equipment, which has resulted in numerous unlicensed contractors skirting the rules and installing equipment in violation of existing laws. These installations by unlicensed contractors are unsafe and inhibit Maryland's environmental goals. HB 1162 would prohibit HVAC equipment distributors from selling to unlicensed purchasers, which will improve compliance with the Maryland's existing license laws. HVAC licenses require years of experience and training for good reason. Unlicensed installers lack the requisite experience to safely install gas, oil, and propane furnaces or install electric heat pumps. Beyond the risk of fire, carbon monoxide, or gas leakage, badly sized or installed systems can exacerbate pre-existing ventilation and mold issues. Improper installations will also run below peak efficiency, increasing energy demand and leading to higher monthly energy costs, higher greenhouse gas emissions, possible refrigerant leaks, and expensive follow-up remedial work. This bill strengthens consumer protections while requiring only modest data collection by equipment sellers, licensed data which many high-quality distributors already collect from their customers when opening an account. Modern HVAC systems are highly complex, especially cold weather heat pumps, and achieving peak energy efficiency performance is an essential part of lowering monthly costs for all Marylanders and minimizing the strain on the electric grid. Thank you for the opportunity to speak today, and we respectfully urge a favorable report on this bill.
Members of the committee, thank you for the opportunity to testify today. My name is Andrew Ozer. I'm the Director of Operations for GAC Services, an HVAC electrical plumbing services company with over 50 years of experience in Maryland. I'm also speaking on behalf of the Association of Air Conditioning Professionals, AACP, a trade association for the HVACR industry representing more than 70 companies in Maryland, Virginia, and the District of Columbia. I'm here today to request a favorable report on HB 1162. This legislation closes an important gap in existing law by prohibiting HVAC equipment distributors from selling equipment to unlicensed purchasers. Maryland's HVAC license requirements provide strong protection for consumers, but unlicensed contractors are still able to purchase equipment, which means under-the-table installs are always a risk. Such installations can be very dangerous, inefficient, and costly to residents. Modern HVAC systems are extremely powerful. HVAC licenses require years of experience and training. Depending on the specific equipment, improper installations risk causing fires, leakage of gas, or dangerous refrigerants, as well as negative health impacts in the home. Badly installed systems can exacerbate pre-existing ventilation and mold issues, run below peak efficiency, increasing energy demand and leading to higher monthly energy costs. Furthermore, many HVAC projects are done on an emergency basis, meaning that homeowners just want their AC or heat back on. We believe it's important to have sufficiently strong consumer protections in place, ensuring that all jobs are done correctly and safely. HB 1162 will make common sense changes to help better implement Maryland's existing license requirements, which will benefit contractor businesses, equipment distributors, and most importantly, homeowners. Thank you for the opportunity to speak today, and I respectfully urge a favorable report on this bill.
Thank you, Madam Chair. My name is Doug Presley. I'm with the Maryland Heating and Air Conditioning Contractor Association. Just available for questions, no testimony.
Thank you very much. Are there any questions for Delegate or his panel? Delegate Chi.
Thank you. Since this has to do with the business regulation, and I appreciate you reaching out to my office in particular ahead of time to discuss this. How do you envision, how onerous would it be for people that this law applies to have to submit an annual report of the transactions? Is that my understanding? Right.
Delegate, we've actually amended out that annual reporting requirement.
Oh, okay. Well, that's good to know. Thank you. All right. Does the Department of Labor have any opinion on this? Do you know?
Delegate, we had briefed the HVACR License Board in their February meeting. They were not able to vote on it at that time. And then they don't meet again until, I think, March 14th.
But they regulate this space, right?
Correct, and the amendments are to their statutory authorities. So the License Board has not taken a position at this time, and I understand that the Department of Labor is waiting for that. But we did brief them and incorporate their feedback into some of the amendments that Delegate Stein has introduced.
Okay, thank you.
Are there any additional questions? Delegate Weigel.
The way I understand it would not forbid a homeowner from doing a self-install on their own home that they own. That's one of the exemptions.
Yes, sir, that is correct. The existing license exemptions apply to homeowners can install it themselves.
Okay, thanks.
Just so to be clear on this, this isn't targeted to take any abilities away from homeowners to do on their own, and it's not even really to target like side jobs or anything like that. The main thing is there's a lot of companies out there, companies who are completely unlicensed, uninsured, and it's to kind of stop them who've kind of stepped away from working for another company, and they lack oversight and they lack the proper regulations that everybody else, myself included, who have all our licenses and everything. It's basically to try to bring them up to that level or to stop them from operating that way. So any unintended circumstances when something goes wrong in a job, it's a consumer protection issue where nobody has any retribution on that.
In your testimony, those folks are already violating current laws.
They are, and that's this isn't a be-all, end-all. We understand that. It's a culmination. We're kind of piggybacking this with existing law. There's going to be some duplicity because obviously the Labor Board and licensing, they have power over people with licenses. They have the ability to pull the licenses back, revoke them, suspend them, fine them, but they have no power over people who don't have licenses. So at that point, the only retribution you have is to go to take it to a criminal level, which is very, very difficult and time-consuming, and most people don't even file any complaints because they understand right from the beginning it's not going to go anywhere. Even if they try to do that, there's a very limited number of complaints for that reason. We did have someone who put in written testimony for this. She's an example I've been using a lot lately. Everybody hears these stories, but she's a mother of 6, and she got took for about $6,500 by an unlicensed contractor. Very, very unsafe install that had to be completely ripped out, incorrect size, the whole thing, and the guy's basically in the wind. There's no way to get to him, and then, this is something that it's not going to stop everything, but people like him who are they're marketing themselves as being a legitimate business and then lying to customers. Ultimately, it's the responsibility of the customer to make sure that people are licensed, but it's very difficult to do sometimes, and you got a lot of con men who that's why they're con men, because they're good at lying. So this is another way to try to not put a wall up, but a very large speed bump along with other laws that are already on the books. Is it going to end it completely? No, but we feel it's going to make a major impact on this.
All right, and Delegate, you said the collection, all the data collection, that's been deleted by amendment.
Delegate, the annual reporting requirement has been deleted. Yeah, it's sponsor amendment. The final version, I don't think has been sent to the committee, but it will be forthcoming.
All right, thanks.
Well, seeing no further questions, I believe that concludes this panel. Thank you very much.
Thank you.
Thank you.
Next, we have House Bill 554.
Sure, come on up. Madam Secretary, we may need a second round, so whoever can make. Yeah, no, you should, you should be up here. Yep. Hi. Okay, we have round 2 behind me, I guess. Mr. Chair, colleagues, for the record, Delegate Lorig Charkoudian asking for a favorable report on House Bill 554. If you're like me, you started to get calls from constituents who have been laid off from the federal government, or calls from constituents who are in a probationary period, administrative leave, and concerned about being laid off from the federal government. Some of the calls that I'm getting are people who are shocked to find out that the Maryland unemployment insurance benefit is capped still at $430. It's been capped at $430 since 2010, when it was set at that, which now in 2025 is the equivalent to $10.75 an hour working full-time, and that's taxed. It's just not enough to survive on. And so our goal with unemployment insurance is that it's enough for people to make it through a spell of unemployment without losing their home, ending up with massive consumer debt, losing their, ending up with massive medical debt, being able to feed their family, while they find the next job that is appropriate and sufficient for them. When people are desperate, they don't make good job matching decisions. And I'm going to come back to that point. The second thing that a very low unemployment benefit level does in our communities when there's massive amounts of layoff is that it's not enough for people to survive on the basic things. And so communities and businesses in the community start to suffer. When large numbers of people, unemployment insurance is designed to be a counter-cyclical economic stimulus tool so that when large numbers of people are laid off, there's still enough money circulating in the community. So it's about the individual, and it's about the businesses in the community and the broader economic health of the community. So this bill increases the UI benefits from $430, the maximum. So we're keeping in place the same formula, which is a percentage of what people had earned for the last year, but increases the maximum from $430 a week to 50% of the average weekly wage, which right now comes to $746 a week. In order to do that, and in general, in order to be responsible in this state, we also need to address the trust fund. The way that we collect unemployment insurance, revenue for unemployment insurance, is through the trust fund. And there's two things that are important to know about the trust fund. One is that we have a tax table which sets the rates. And so I have here as an example, tax table A, which ranges from 0.3% to 7.5%, depending on the history of how often an employer has laid people off. So they get a higher or lower rate depending on how often they've laid people off. The issue comes in on how much of that same tax rate we're actually going to tax, and this is called the taxable wage base. And so in 1992, I feel like, no, all the old heads are in here, but we actually do have a member who wasn't even born yet in 1992. He's not here right now. In 1992, we set the taxable wage base to $8,500, and we are still only applying this tax to that same $8,500. And that's important because when we talk about, if we think about, for example, our sales tax, we say sales tax is 6%, and it's 6% on 2025 prices. If I were to tell you I would prefer to pay my sales tax, my 6%, on prices from 1992, you would say, like, that's just an unrealistic concept. And if I were to turn around and say, well, you're raising taxes on me, I would say, no, we have a 6% tax rate, and we're putting it onto 2025 prices because that's what we need to do for our economy to work and for our budgets to work. So when we talk about raising the taxable wage base from a number that was set in 1992 to a number that's appropriate for 2025, we are not raising taxes. We are updating the baseline, the prices, if you will, on which we are applying the very same taxes that we have had in place for the last 40 years. And here's why that's important. If you, in my testimony, you have a couple of charts, and the first chart shows what happens if we don't do anything. We don't increase the maximum benefit, and we don't increase the taxable wage base. And what you can see from it is two different scenarios. One is if we maintain a UI, an unemployment rate of 3.5%, and the second if it goes up to 5%. The Secretary has a scenario of a worst-case scenario that she'll be discussing shortly. But what you can see is even if we do nothing, our trust fund runs into trouble. And that makes sense. If we're still basing it off of 1992 prices, it is going to run into trouble. So then the next thing that you'll see is how do we compare to other states? This is at the end of my testimony, and it's a chart that shows the taxable wage bases across this country. And what you can see is Maryland is over here in the taxable wage bases. The U.S. average is about 20,000, and then you can see all of these other states that have much higher taxable wage bases than Maryland does. So we have some catching up to do. The final chart that you'll see is a modeling, and I want to thank the Department of Labor. Last year we had some modeling from a couple of years ago. We found that we needed to update it to more current information. The Department of Labor worked really hard to get that done, and so we have an opportunity to see the modeling of if we implement this bill in its entirety, which of course we're open to amendments and working with folks. If we implement this bill in its entirety, how would the trust fund's health look like? And that's this final chart, and you can see a stable trust fund with an increase in the taxable wage base and an increase in the benefits that we're paying unemployed workers. I want to talk a little bit about the opposition, because I think the history on this bill is really important. One of the things that opposition is going to say is, let's talk about it some more. Let's have some more committee meetings. We want to be part of the discussion. So it's really important that we talk about what the history of this discussion has been. In 2021, I had a really significant, a substantial bill that did a number of the things that are addressed in this bill. And in 2021, the decision was made that, no, we couldn't move forward with that. It was a lot of stuff. Let's study it instead. And so over 2021 to 2022, massive studies were done. The Department of Labor hired consultants from the Upjohn Institute, and they studied it, and then they did presentations to the UI Oversight Committee, and all of the opposition that you're going to hear today had a chance to discuss, to ask questions, to weigh in. They did presentations to this standing committee, and out of that, out of those presentations, out of those discussions, I brought in a bill the next year. In preparing for the bill for the next year, I met multiple times with the Chamber of Commerce, with NFIB, and with the Retailers Association. I asked them repeatedly to tell me if they were concerned about things, what other proposals do they have? I understood they didn't like the bill. What other proposals do they have? What other numbers would they suggest? They never presented me with another proposal. Instead, they continued to talk about other issues such as ghosting. Now, at the time, I thought ghosting was a bit of a red herring, but I accepted on face value that that was a serious concern they had about the structure of UI. And what they mean by that is people who are on UI need to engage in job search requirements on a weekly basis, and they have to tell MDL what they did for their job search. And the ghosting accusation was that because businesses had people who were supposed to show up for an interview, and they didn't show up for the interview, the businesses were suggesting that perhaps they didn't show up for the interview because they said they engaged in that process, they put in that application only because MDL requires it, and actually these people were misusing unemployment insurance because they weren't really actively searching, they were, and that's why they were ghosting. Now, I thought it was a red herring at the time. I know members of this committee had legitimate concerns, and so I said, okay, we'll wait one more year on this really important bill. Let's take a look at that. And so Delegate Adams had a bill that required a study to be done by the Department of Labor. The study was done, and hopefully folks have access to it. I can get it to you if you don't. Here's what it found. It found that the Department of Labor they do audits on people's job search requirements. So they follow up, and people say, I applied at XYZ, I applied at McDonald's. They call McDonald's for 5% of them or some percent of them and say, hey, did Lorig actually apply? What they actually found was they were not able to do these audits as comprehensively as they'd like because, do you know who was ghosting? The employers. 60% of the employers either did not reply to the audits or were not able to provide sufficient information that they could determine whether or not the job seekers actually had applied. So the point is, we have something in place to check up on people, to make sure that they're actually applying where they say they're applying. And the problem with that system is not the people on unemployment, it's employers who are not providing sufficient information. The second thing that this highlights is that multiple other states, because the bill required that they look at other states, use essentially the similar tools that Maryland has. And the third thing that it highlighted is that if ghosting is a problem, there is an ombuds that employers can call and use if they feel like they've been ghosted. So if somebody doesn't show up for an interview and they think the person is misusing unemployment, not following through, they can call the ombuds. So I think that at this point, we have sufficiently addressed all of the issues, and we have been in this conversation for 6 years now. And my hope had been that we were going to address this issue while the sun was shining, that we were going to address this issue, the challenges with unemployment, before we were facing a potential unemployment insurance crisis. I'm disappointed that we hadn't been able to, but it's not too late. And I feel like this is now the moment that we need to go forward and address this. I want to highlight one other thing, I'm sorry, that I think was said in the Senate, in the opposition in the Senate, which is this issue of, do people stay on UI longer if benefits are higher? There is a small increase in the amount of time that people stay on UI when benefits are higher. And what the Upjohn modeling showed, at the time in 2019, the average time on UI was 15.8 weeks. And it showed that if we increased the UI benefits to 2/3 the average weekly wage, which is significantly higher than what I've proposed, it would increase the time that people are on unemployment by 2.5 weeks. What that's showing is that we're doing better and more efficient job matching. If I am an economics professor and I am forced, because I'm desperate on unemployment, to take a job that is not in my profession, and so I take a job as a cashier, I'm only going to be in that job for 2.5 weeks until I find the job as an unemployment insurance professor. So having wages so low that people are forced to take jobs that are not a good fit for them is only going to waste and be inefficient for employers and employees. We need to get the right balance of making sure people have enough to live on and they're not desperate, so that when they're finding jobs that are right for them, and we're doing that job matching in an efficient way. I'll stop there. I will take questions if folks have them. I do, yeah. Would you like to go next?
I was on information.
Your information.
So it should go to your positive.
Mr. Chairman, Mr. Vice Chairman, ECM committee members, thank you for the opportunity to come here today and speak in favor of HB 554. My name is Rico Albuquerque. I'm a member of IBW Local 24. We represent about 2,500 electrical workers from Frederick all the way to Ocean City. Last year I came in front of this committee and I told a story about the last time that I was laid off. UI benefits were $430 a week, and that was, for me and my family, just enough to get by. Fast forward to last year or to today, that same $430 a week is woefully inadequate. I want to tell a little bit of a different story. The first time that I was laid off, and I'm not laid off all the time, all right? I've been working since I was 16 years old. I've been laid off 2 times in my life. I've been on UI benefits 2 times in my life. The first time I was on UI benefits, I used to work at a printing press, and a company came in, bought the press, shut it down, laid everybody off. And print is a little bit of a dying industry, right? So as I was trying to find comparable employment as a printing press operator or working in a warehouse or something along those lines, unemployment benefits were enough to bridge me to finding my career as an electrical apprentice and beginning my career as an electrician. And that's what unemployment benefits are. It's a bridge for Marylanders to find their way to their next comparable employment, to their next job. And right now, today, that bridge is missing planks, the ropes are frayed, And I don't know that we would trust that that bridge is going to hold when Marylanders are putting their families on that bridge, trying to get to the other side of their employment opportunities. And for those reasons, I'm here, and I hope you guys give a favorable report on HB 554.
Chair, Vice Chair, members of the committee, thank you for the opportunity to testify in support of House Bill 554. My name is Lona Muckle, and I'm the Senior Policy Associate with the CASH Campaign of Maryland. CASH stands for Creating Assets, Savings, and Hope, and we promote the economic advancement for individuals and families in Baltimore and across Maryland. More than half of our clients earn less than $20,000 a year, with many earning less than $10,000. CASH provides a variety of services to Marylanders, including free tax preparation and benefits counseling. Last year, our benefits team was able to help over 300 households across the state receive benefits, including unemployment insurance. Unemployment insurance is a basic and essential safety net for workers who are temporarily unemployed through no fault of their own. Once they're disconnected from the workforce, it can be difficult for them to reconnect. UI is a critical safety net for these workers because it helps to combat some of the barriers to finding employment, like affording food, housing, and transportation. Having a robust safety net protects workers from excessive debt and falling behind in paying on their bills. It not only helps them find employment, it ensures that once they do find employment, that they are not as financially strained as they would have been. At least 1/5 of Marylanders struggle to pay for basic expenses, and around 20% of Maryland households experience income volatility. They should not have to experience greater periods of financial stress due to temporary unemployment. This bill would ensure that Marylanders are better supported during these periods of unemployment and that they are able to provide for themselves, their families, and are set up for success when they do re-enter the workforce. For these reasons, we urge a favorable report.
Good afternoon, Mr. Chair and members of the committee. I'm Donna Edwards. I am president of the Maryland State and DC AFL-CIO. You have our written response. However, I think that the sponsor did a very thorough job of laying out the details of this bill. I have been on the UI Joint Task Force since the early 2000s, and I can speak to the necessary to have the trust fund, because during the recession in 2008 and 9, Maryland, because we had such a strong trust fund in UI, we were only one of 3 states in this country that did not have to pay interest when we borrowed money from the federal government. We didn't fix it then, as we move forward, saying that we needed to fix the system. And then COVID hit, and we had a very difficult time, and were bailed out by the federal government. And now we came out of that, and we still didn't face the truth that we've done nothing in 30 years, that we really need to fix the system. And now we are facing a tsunami that is coming at us very quickly and is going to impact thousands of Marylanders and our businesses. Every dime that somebody gets in unemployment insurance goes back into the local community and our state, every dime. And it is a bridge, and it is something that helps people find the right job, the right fit to get back into our economy as wage earners. So we urge the passage of House Bill 554 and look forward to working with all of you.
She's informational.
Mr. Chairman, I realized I'm informational. I came out of order. I'm sorry.
Yes.
Do you want me to go ahead?
And I'm going to let.
Wait. Donna, are you running?
Yes.
Okay. Does he want to do other supports first?
Good afternoon, Mr. Chair, members of the committee. For the record, my name is Tom Clark. I represent the electrical workers of Local 26. Unemployment insurance is necessary to help Marylanders that have worked consistently and have been unfortunately laid off through no fault of their own. I can speak for construction workers who often need this assistance between jobs. Construction work is different from most businesses because electricians and plumbers are not overhead. We're production. As soon as work slows down, even for a day, layoffs are possible. It's not an easy life. It's something construction workers deal with nor is it easy for Maryland businesses that must lay off people. I know we have a lot of contractors on the committee, and it's tough to give a reduction in force to a valued employee. But we need to update the unemployment insurance system that is suited for 2025. I do commend the sponsor of this bill because work is good right now, but it always won't be. I go back to the saying that time to fix the roof is when the sun is shining. And work is good, and the UI Modernization Act is addressing this issue before it's raining cats and dogs. I thank you for your time, and I ask for a favorable report on HB 554. Thank you.
Yeah, I think so. So she's here informational. The question was, should she speak
Yeah,
now and then
I
take
guess
questions, or do
if you wanted me to do technical questions, that's why I came up with those.
Thank you, Mr. Chairman. I just want to follow up with what you termed ghosting accusation. I've actually experienced firsthand of folks that use these online platforms, set up interviews, they never show up. And at the time, I think I asked this question last year, there really wasn't any formal process. And I'm guessing this bill doesn't provide a portal or anything for employers to actually report when an applicant does not show up for an interview. It seems like in this day and age with technology, the department could easily set something up to do that. I heard you say that they could call the ombudsman. So, Madam Secretary, I'd be interested to know how many calls to an ombudsman, who I'm not even sure the number is published. What was the result of those investigations? How many folks were actually denied employment benefits for ghosting interviews?
I want to clarify, though. I didn't say ghosting doesn't happen. Like, people are rude. I'm sure people are ghosting. The question was whether the people who are ghosting you on the interviews are receiving unemployment insurance. I mean, people could be signing up for interviews and then ghosting, and it may have nothing to do with unemployment
Correct.
insurance.
The employer has no way of knowing, but there should be a way for the employer to report that to the Department of Labor.
That's what they have the ombuds for.
John Smith didn't show up for an interview today, and they should be able to follow up with that to see if.
So they would follow up to see if he's on unemployment and if that was his unemployment.
Right, and I think the Secretary can probably answer that question, how that works.
Yes, I can. I don't believe we are getting a lot of complaints about this, Delegate. I mean, I understand that it does exist. Employers can complain about it. As Delegate Charkoudian already covered, we do try to get answers from employers about this, and we actually don't get a lot of responses.
But I don't think you're publishing. I wasn't aware there's a number I can call to report somebody ghosting me on a job interview.
We can certainly look at making this information more readily available so that the employers can reach out. And but I do want to note, just because an individual failed to show for a particular interview doesn't mean that they didn't comply with the work search requirements under the statute. They may have, for example, gone to 3 other interviews that week.
We have no way of knowing, neither do you.
And our job is to verify whether they complied with the minimum requirements.
But it seems like there would be an easier way with technology to have employers report that.
We're certainly happy to look into it.
Thank you.
Chair, and I guess mine is more of a comment to Madam Secretary. I did, as an employer, receive information on how to notify the Department of Labor if this were taking place. So I do feel like employers, people who are conducting interviews, are getting the information if they pay just a little bit of an attention. Second, I just pulled up our portfolio, and in the last 4 months, we've interviewed 23 people. Not a single person ghosted us, not one. So it's really not a thing across the masses. I think that most people who are looking for work, they're trying. At least that has been my experience. Doesn't mean I've hired all of them, but they've at least shown up for the interview. So I think that that is important as somebody else who is an employer to push back on that narrative.
Sure.
Thank you. I'm starting to think I'm invisible. Thank you, Mr. Chair. Delegate, you said what year this rate has not been changed since?
There's 2 different things we haven't changed. We haven't changed the taxable wage base, which is behind the health of the trust fund, since 1992.
1992, okay.
And we haven't changed the maximum benefit level since 2010.
Thank you so much. Unbelievable. Thank you.
Thank you.
I believe that are all the questions for this panel.
Thank you.
Very much.
Thank you.
Dawn Connolly, one virtual, are we on today?
Good afternoon, Good afternoon, Chairman Wilson and members of this committee. My name is Sean Conley, and I'm a staff attorney from Maryland Legal Aid. MLA asked this committee to report favorably and pass House Bill 554. MLA has represented thousands of people who have filed for unemployment insurance. We believe that this bill is a crucial step in helping people maintain their purchasing power, ensuring that they can cover essential expenses. This bill can help reduce financial strain and mental health challenges associated with job loss. Moreover, people receiving higher benefit amounts are more likely to spend money in goods and services. This can sustain businesses and ensure better economic stability. Increasing the weekly benefit amount may reduce other public support benefits a person seeks and applies for, and as a result, reduces dependency on public assistance programs. Children in households experiencing unemployment can also benefit, improving their nutrition, access to health care, and educational outcomes. Sufficient unemployment insurance can put food on the table, pay rent, and keep families from falling into poverty during periods of joblessness. We have successfully represented thousands of clients in unemployment insurance cases where the difference made saves their homes and makes it possible to appear for job interviews and effectively obtain new employment. Maryland last updated the method used to calculate the weekly benefit amount in 2010. In addition, the dependent child allowance was last updated in 1988. That's 1988. The premiums paid into the system, the weekly benefit amount, and the dependent child allowance seriously needs updating so that the system remains viable. MLA urges a favorable report on and passage of House Bill 554. Thank you, Mr. Chairman.
Thank you very much. Next, we have virtual Christopher Meyer. That's favorable. You can go ahead, sir.
Apologies. Thank you. My name is Christopher Meyer with the Maryland Center on Economic Policy in support of House Bill 554. Unemployment insurance is a key lifeline for workers who have lost their job through no fault of their own. It's also one of the fastest and most effective ways to protect our economy in a downturn. And it's especially important today as federal policy upheavals threaten hundreds of thousands of Marylanders' jobs. But our UI system is trapped in amber. Benefits have long been capped at $430 per week and are much less for low-wage workers. For those of us still mentally catching up, that's equivalent to just $350 pre-pandemic. This bill would make benefits a little bit better and keep them in line with future growth. A 2021 IMF report found that every dollar in unemployment benefits increased earnings, not just income, but earnings, by $1.92. Furthermore, strengthening benefits improves the fit between jobs and workers' skills, which ultimately means a healthier economy. Strengthening our UI system also advances racial justice. Unemployment rates for Maryland workers of color range from 1.2 times the white rate for Asian workers to 1.8 times for Black workers. That's people who are actively looking for a job but can't find one. The bill also improves Maryland's fiscal health by ensuring our deeply outdated taxable wage base keeps up with the economy. Keeping an out-of-date taxable base requires higher and more volatile tax rates. It's worth keeping in mind that Maryland today derives a smaller share of state and local revenue from taxes on businesses than any other state, according to Ernst & Young. Increased benefits do not come out of the general fund, and in fact, better benefits means stronger consumer spending, which means modestly higher tax revenue. This bill is the right choice for Maryland's economy. I respectfully ask for a favorable report. Thank you.
There are no questions. Moving on to the unfavorables. Hannah Allen. Michael Halloran, Kaylee Locklear,
Mr. Chair, if it pleases the committee, I'll go ahead and fire off. For the record, my name is Michael Halloran, here today representing NFIB, in respectful opposition to House Bill 554. Look, the broad concern from an employer standpoint continues to be the substantial increase of UI taxes. Remember that Maryland employers are the only ones that pay in to the Unemployment Insurance Trust Fund. According to the fiscal note, the bill roughly doubles employer UI taxes. Quote, small businesses pay significantly higher state UI taxes due to the increased taxable wage base beginning July 1 of this year. There's also concern over the automatic increases in this bill to these taxes in the future years. If you recall the very vigorous debate over increasing the state's minimum wage, only a few years ago. I know we're all trying to put that bias to debate at least. But this committee wisely removed a provision from the bill that sets automatic increases. This bill has such automatic increases. Look, Maryland's unemployment rate remains one of the lowest in the nation and well below the national average. The final point I'll bring up is if you look at the fiscal note, I believe it's on page 5, talking about state revenues versus expenditures. I believe you'll see a number there that says state revenue for the UI Trust Fund will increase by about $900 million. It's a $900 million tax increase on our employers. At the same time, the expenditures is $1 billion in 2028. So my math tells me that that's a $100 million difference. It also tells me that, according to this fiscal note, we'll be right back here in 2028 having the same discussion. So for these reasons, we respectfully request an unfavorable report for House Bill 554. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Hannah Allen here today on behalf of the Maryland Chamber of Commerce in respectful opposition to the bill. You know, I think the feedback we've certainly gotten from the business community echoes exactly what my colleague, Mr. O'Halloran, has said before you today. The main concern that we consistently hear about from members is the jump that this bill is presenting. It's presenting about a 76% increase in the taxable wage base, going from a fixed number of $8,500 to a number that essentially grows with inflation, grows with wage growth. You know, I will say employers also certainly understand the need to make sure that we have a solvent trust fund. I've also received questions about the fiscal note that Mr. O'Halloran pointed out, and where that puts us long-term with solvency. But because employers solely fund the trust fund, we want to make sure that a larger conversation happens, ideally with the Joint Committee on UI oversight. But, you know, I'll end with, we're not viewing this change in a vacuum, right? There are tons of other proposals before the legislature this session that are looking at increasing the cost of doing business and the cost directly on employers and businesses in the state to fill some of the budget deficit. So that is the position we come from today, but we look forward to an engaging discussion with the sponsor and come ready to, you know, help provide options from employers. Thank you.
Good afternoon, Mr. Chair and honorable members of the Economic Matters Committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are in opposition to this legislation. I will adopt the comments of my colleagues, so I don't have to repeat any of that, but I want to use a different number here. We're talking about a $575 million increase in revenues from 2024 to next year. That is in your fiscal note. That is on page 4. The state's Unemployment Insurance Legislative Oversight Committee has not met formally since before COVID. And that was a very, very important part of these conversations, as it was reflective of both chambers, advocates, and businesses. And I still think that that's important for it to be convened and meet. That was the conversation that we had on the Senate side, so I'll throw that out there. And finally, the study. There's a lot of focus on the study today, and I really need to hit on a couple of things here. I have been working on this issue now for 9 years. And for years, over multiple administrations, I have asked about verification information. Not only that, but I went to my actual members' locations and I sat down with their HR teams. I looked at their systems. How could they possibly insert this information into the system or report this? And I was told, by the way, when I talked to the Department of Labor about this for the past 9 years, there is no verification that is occurring. So I'm a little taken aback by the information that was included in the study that has never, ever been information that has been shared with me. This ombudsman information is new, and I think it is incumbent upon business community and our agencies to work together when there's information like that that needs to be shared with members, because that's also new to me. I continue to have problems with the active search for work requirements. I've expressed over the years there's truly only one that has to occur in the state, and the others are you created a resume online. So with that, I'll end there. Glad to answer any questions.
Delegate Adams.
Thank you, Chair. So I was looking at the sponsor's graph, UI taxable wage bases by states and how Maryland needs to quote unquote catch up. A state with a lower taxable wage base includes the state of California. And so I'm not sure what the conclusion that the sponsor was making on this, other than say there are some states that have a more stable employment setting. In other words, it's not as incumbent on the Unemployment Insurance Trust Fund in these other states like Washington State to do what we're doing in Maryland. But the idea that we're just going to pass a bill because we need to catch up sort of smacks of just typical government for the sake of government. Like, what are we trying to fix? And now I'm going to ask the second question on that, but can you just comment, if you'd like, on the fact that many other states like California have lower taxable bases and that this isn't the metric that we should be using to fix or amend the UI Trust, the uninsurance program?
I'll take a crack at it, Delegate Adams.
Yeah.
Look, I comparisons to other states can certainly be useful in some regards. But, you know, with a program such as UI, where there are so many different variables dependent on each state, you know, I think it drives home your point. The way I see it is that, you know, when we take a graph and we try and distill everything down on why we should do something, I think that's where you may run into issues. You know, there was discussion about the business community coming to the table with different ideas, and certainly a lot of credence was paid towards verification. You know, one idea that I believe I've been on the record as talking about, and it refers to the Upjohn report, and talking about, you know, comparing to other states. There are other states that have employees pay into the UI Trust Fund.
Mm-hmm. Different models.
I've been on the record for that, but it's a different model. It's you know, so this idea of different variables and trying to play catch up, and, you know, as my father likes to say, who shot John? Mm-hmm. You know, I think that's where we're going to get, you know, kind of scrambled on what the issues are.
Yeah, so my second question really kind of goes to the state of Maryland right now as it relates to a series of things, but not least of which is we surely are going to have tax increases this year. I mean, that's just going to happen. And I don't think it's good for the legislature to just say we need to catch up on UI, when I think the state of Maryland is going to have to do a lot if they intend on meeting all these goals with education and energy, all these different priorities. They're going to come with their own set of tax increases. I would imagine you would say that if you're a business owner in the state of Maryland, you're probably curious at worst, but scared at best about what this outcome is going to look like. And this is just one piece of a puzzle. You're going to roughly double. That's what the fiscal note says, your UI taxes.
It's meaningful, not just for businesses, it's for local government and state government as well. That's notated in the fiscal note.
Right. So I think it tells a story that needs to be told before we're ending session. If you pass a bill like this, what else are we doing here in the state to help businesses?
Thank you, Mr. Chair. I just want to clarify that there's a revised fiscal note. They had flipped the numbers, so I appreciate your concern about the sustainability of the trust fund, which it's not going to be sustainable if we don't fix this, but thank you for raising your concern about that. The revised fiscal note says, based on its own wage growth and unemployment assumptions, Maryland Labor estimates approximately $1 billion in expenditures and, revenues of $1 billion, expenditures of $900 million. So,
Interesting, okay.
yeah, so this does in fact, and this is why I would actually encourage you to look at these graphs as what we're trying to do, as opposed to, it's not just about catch-up, it's about actually a sustainable system. And I'll leave it at that. Thank you.
Seeing no further questions, that concludes this bill hearing. Next, we will go to Ms. Delegate Ruff here. He is House Bill 1126, and Chris Dews. Chris is here too. You guys can start when ready.
Thank you, Mr. Chair, esteemed members of the Economic Matters Committee. I come before you today for the record, Delegate Malcolm Ruff, District 41, Baltimore City, to introduce a bill that will provide a critical lifeline for parents struggling to meet their child support obligations and to the children that are being deprived of this essential financial support. House Bill 1126 establishes the Child Support Arrearage to Work pilot program. It's an initiative that will make a profound difference in the lives of many Marylanders. Child support arrears have long been a source of stress, embarrassment, and frustration for individuals, families, and for the state as a whole. For many parents, especially those who are unemployed or underemployed, the inability to pay child support has become a barrier to both personal success and financial stability. In fact, the consequences of debts owed to state agencies represents one of the biggest barriers to employment aside from a criminal record. Child support arrears trigger consequences such as collections and driver's license suspensions, but hopefully we'll pass Delegate Tolles' bill, House Bill 681, to assuage some of that. But it traps people in a vicious cycle of poverty. Despite their best efforts, folks in arrears often find themselves trapped under mounting obligations that only worsen over time. So this pilot program seeks to break that cycle. The bill creates a pathway to employment for individuals who are unemployed and struggling with child support arrears by connecting them with meaningful job opportunities within the state, including positions in state government. This is not just about finding work for people. It's about empowering them with the tools, opportunities, and resources they need to regain their financial footing and fulfill their responsibilities as parents. At the core of this program is the belief that stable, gainful employment is the key to addressing child support arrears. When parents are employed, they are in a better position to meet their child support obligations, but more importantly, they're better able to support themselves and to contribute positively to their families and communities. This program acknowledges that securing a job can be difficult, particularly for those who have a history of arrears, but with the right support, it's possible to turn people's lives around. So working in partnership with the Department of Human Services and the Department of Budget and Management, the Department of Labor will implement this pilot program by sharing secure, relevant information across these three agencies. We will create a system that allows us to identify those in need and connect them with employment opportunities in a manner that is respectful of their privacy and their dignity. The pilot will also provide us with valuable data and feedback that will guide the future of the program and will potentially serve as a model for other states. And in fact, the impetus behind this bill was a bill that I found in Illinois that was passed that is that is nearly identical to this bill. And so we can be one of the leaders in the state in making sure that people get back to work. By next year, the Department of Labor will report back to us with recommendations on how to strengthen and expand this initiative, making sure we continue to meet the needs of our communities and families. I want to emphasize that this is a matter of giving people tools and opportunities to succeed on their own. It's about fostering self-sufficiency, promoting responsible parenting, and ultimately benefiting Maryland's economy by helping more people join and rejoin the workforce, contribute to society, and provide for their families. So I'm asking for your support in passing this bill. I believe that by giving individuals a meaningful chance to find work, we're not only addressing arrears, but also investing in our state's most valuable asset, the future of Maryland's children. For these reasons, I urge a favorable report, and I thank you for your attention.
Christopher Dews, representing both Out for Justice and the Center for Urban Families. Center for Urban Families operates out of Baltimore City, Northwest Baltimore specifically, where there is a high concentration of individuals who have child support debt, and specifically facing the repercussions that the delegate had mentioned, from tax interceptions to license suspensions to wage garnishments and more. Connecting them with employment is what the center is known for, it's what they do best, and it's a really big deal having to fix this issue. Now, what's really good about this piece of legislation is that it is a combination of a partnership between the Department of Labor, Department of Budget and Management, and DHS. As the fiscal note stated, there's about 2,000 individuals that would currently qualify for this, and we think it is a brilliant partnership to ensure that individuals, especially if they are working, do not fall behind on child support so that they don't end up in a position where, again, wages get garnished, licenses get taken, which of course then doubles down their inability to secure employment, that their credit scores are not damaged, all of which occurs if you fall behind on child support. I think this is a great piece of legislation. It will be very, very good for workforce. It's going to be good for individuals also returning from incarceration who disproportionately is supported by Out for Justice, and we think that this is just a good piece of legislation. Happy to answer any questions that anybody may have about the impact of child support, especially when people don't have access to employment. Thank you.
Is Zach Alberts on? Okay, we'll go to the one virtual, then we'll take questions. Go ahead, Mr. Alberts. Go ahead.
Hi, Zach Alberts with the Center for Urban Families. Would like to thank Delegate Ruff for introducing this bill. Both Delegate Ruff and Chris did a wonderful job of saying why this is so important. The only thing I would note is that 2/3 of Marylanders on child support are low-income Marylanders. When you fall behind in arrears, you are one of the most economically disadvantaged people in our state. And whatever creative ways we can find to connect those folks to work is just crucial to making sure that they can meet their obligation to financially support their children. And so we would urge a favorable report. Thank you.
Thank you. Seeing no questions, that concludes this bill hearing.
Thank you, Mr. Chair.
Thank you. Next, we will go to House Bill 217. Delegate Rogers. Delegate, if you have a panel, you want to bring them up?
Want to sit on my lap?
All right. Anybody in gold can start.
Good evening, Economic Matters Committee, Chair, Vice Chair, and all members. My name is Cree Coley, and I'll be testifying on behalf of Delegate Rogers. I respectfully request a favorable report on House Bill 217. This bill will repeal the requirement that certain firefighters and other specified related fields experience partial or total disability or death for hypertension to be presumed to be an occupational disease that was suffered in the line of duty and is compensationable under compensation law. Currently, hypertension is recognized in a statute as an occupational disease presumption under 9503 of the Labor and Employment Article. This would amend that section to remove the requirement for disablement. Currently, under the prevailing case law, disablement is generally considered 3 or more lost days from work. The Workers' Compensation Commission has been denying hypertension claims under 2 specific scenarios. The employee is placed on medication after visiting a physician and returned to work, or the employee is placed on medication and misses more than 3 days of work as directed by a physician, and claims are still being denied. Under either of these above scenarios, the Worker Compensation Commission is essentially nullifying the clear intent of the General Assembly that hypertension is a presumptive occupational condition under 9503. For these reasons, I respectfully request a favorable report on House Bill 217.
Good afternoon, Mr. Vice Chair. Jeff Buttle, President of the Professional Firefighters of Maryland. We represent over 10,000 active and retired firefighters and emergency medical services personnel throughout the state of Maryland. We are here in support of House Bill 217. And what we're trying to do, this is a very specific area of the law that applies just to firefighters. And simply put, our firefighters are having problems oftentimes at the Workers' Compensation Commission getting these claims approved because of the interpretation of what constitutes disablement for hypertension. What we tried to do with this bill was simply incorporate our National Fire Protection Association medical standards, that if the firefighter is above the thresholds defined in those national medical standards, which we have to meet in order to be qualified as a firefighter, and they're on medication for a certain period of time, that in this specific instance for a firefighter, that is what constitutes disablement. I know we've heard from the opposition that these are not issues at the commission, but Mr. Vice Chair, we actually have a firefighter here today that's going to tell his story about how it actually was an issue at the commission. So we'll have somebody here to tell their real-time story. But we hope to be able to work with the committee. I know this bill has been before it, this committee for a couple years, and we're hoping this year is the year that we can finally get this resolved and get this cleared up in statute so our firefighters can get the benefits that they're entitled to under the law, which actually have been around. This hypertension presumption has been in the statute and been part of the law since 1971. We're just trying to clarify the disablement piece of it with this piece of legislation. Thank you, Mr. Vice Chair.
Good afternoon, Matt Darby, the Darby Law Group. Thank you for the opportunity to speak in favor of this bill. I and a couple of my colleagues that are also here practice law in this area. We each have handled hundreds and hundreds of these hypertension cases, sometimes successfully and most often successfully, but this is a major impediment. And I like to approach it from the perspective of, whatever we can do to promote firefighters taking higher recognition of their risk for hypertension and achieving and seeking appropriate medical care is something that we ought to do. And we should do it not only from the perspective of the obligation that we as citizens have to these heroic people, but also from the perspective of cost. Now, most of the time, cost is brought up by the opposition in these types of bills, but I like to point out that, and we've all handled these cases, would share this experience with you, that hypertension is a risk factor for many, many other conditions. From cardiovascular disease to left ventricular hypertrophy to aneurysms to blindness to kidney failure to all those things. And so to recognize this in a way that it promotes the firefighters receiving the medical treatment and compensation that they should is going to go far in avoiding these more complicating factors, which compared to baseline treatment for hypertension are much, much more expensive. So I think from a cost perspective, whatever we can do to promote firefighters in getting the appropriate treatment and recognizing this as an easier path to that treatment is important and will be helpful and the right thing to do from a cost and an ethical point of view. So thank you.
Good afternoon, Mr. Vice Chair, members of the committee. Thank you. My name is Dale Bowen, and I'm representing the Maryland State Firefighters Association in the 340-member departments. I'm also a 38-year first responder with the Huntingtown Volunteer Fire Department in District 27C, which is relatively represented well, I guess I would say. The bill definitions have already been presented by the other panelists here, so I won't get into that. I will tell you that hypertension affects about 3 out of 4 first responders. Hypertension raises the risk of heart attack, stroke, and more than half of the deaths among firefighters in the line of duty are related to cardiovascular disease. First responders with hypertension experience greater blood pressure surges in response to alarms than their non-hypertensive coworkers. The volunteer and career first responders that protect the citizens of Maryland go through significant amounts of physical and psychological stress, and it's time to recognize hypertension as an occupational disease. As I said, I'm a 38-year volunteer with the Huntingtown Volunteer Fire Department. I still respond to house fires, medical emergencies, motor vehicle accidents, and yes, the occasional cat in the tree. It is for these reasons that I request a favorable report on House Bill 217. Thank you.
Thank you. My name is Charlie Schultz. I'm an attorney representing firefighters in the state of Maryland. I'm here to testify favorably for House Bill 217. I want to just break it down to make this really simple for everyone who may not know, but proving a hypertension case, and I explain this to my clients, we have to prove three main things. You have the disease, that the disease is caused by your job, and that you're disabled by it. The presumption applies to the second prong of that, the causation piece. That's not what we're here about today. We're here about the third prong, this disablement piece, and this is where we're running into trouble. And the reason why we're running into trouble is because of the unique nature of hypertension. There are other diseases that fall under this presumption: cancer, heart attacks, heart disease in general, lung disease. But hypertension is included in the presumption, but it's unique when compared to those other conditions, and that's why we're here on only hypertension. Hypertension is commonly referred to as the silent killer by medical professionals. A lot of people have it, don't realize they have it. A lot of people have it and don't realize how high their numbers may be. It's a disease that oftentimes has no symptoms. And that's exactly why the way the law is written right now, where you need to have symptoms that prevent you from being able to do your job, isn't working, because our firefighters are out there fighting with high numbers from a hypertension standpoint, and dangerously so. And we can't protect them and file the claims for them because they haven't been disabled as the law currently is written. So that's why we're here to present to you a solution to that problem by redefining disablement. We still have to prove disablement. The opposition has indicated that we're abolishing it altogether. We are not. We're just simply categorizing it in a way that's more appropriate for a disease that oftentimes does not have symptoms but can still be fatal. Thank you. I appreciate it.
Good afternoon. My name is Monty Arrington. I am a 38-year active firefighter with 24 years of career service with the BWI Fire and Rescue Department. That is a state fire department, the only state fire department under the state of Maryland. I come to you with a story based on my own experience of being diagnosed in 2014 with hypertension. And just as recently, at the end of the last year, at work at a staff meeting, and suffered from a asymptomatic episode where my paramedics had to assess me, and it was determined that my blood pressure was extremely high, which landed me home for 7 days with treatment. And mind you, I was already on medication. So my physician, worked things out and said, well, we'll try to get you stable so that you can go back to work, because that was my interest, going back to work. Of course, my health is important as well. But my story is that a claim was filed, and once that claim was filed and we went to court this year, it was denied. It was denied based on disablement. I'm not sure, where they don't find, this to be a debilitating, illness. I wake up with headaches. I am deconditioned to a point. I work out, but, you still just don't have that energy. I have 2 sons that are in the fire service as well, and my thought is like, what's to be expected, in the future for them. And this bill needs to be passed. This is important that we get this done. I'm not sure what the issue is with the hypertension part of everything that people don't understand. So it is very important that, this bill is definitely looked at and it's, passed. I would really appreciate it. And I think going forward, it's going to help out a lot of folks in the fire service. And not only just the fire service, our police officers are doing the same thing and they'll live with the same thing. Thank you.
Thank you. Chief Arrington, Chief Bowen. Chief Arrington, Chief Bowen, thank you for coming today. Thank you for your service. I just want to talk real, because I'm in the trenches every day fighting for the firefighters and police officers for hypertension. I've tried probably over 15,000 cases in my life, and over 1,000 hypertension cases. You're going to hear from our opponents to this bill that say, well, this is no different than any other occupational disease. You have to have disablement for every occupational disease. Well, I was here with you guys last year when we passed our hearing loss. Hearing loss is an occupational disease. You don't have to miss work for that. We're here, and you're going to hear that you have to be disabled, that the firefighter has to miss work. Well, as Mr. Schultz said, hypertension is a silent killer. If you don't miss work because you have a headache, because you're asymptomatic, your hypertension gets worse. You may have a stroke. I have another firefighter, I won't mention his name, but his hypertension medication was $800 a month. He did not take it as he should have taken it, and he suffered a stroke, followed by a heart attack. He's now passed away. So when our opponents say they need to be disabled, okay, carpal tunnel syndrome is an occupational disease. It doesn't kill you, okay? Hypertension does kill you. So when they get up here and tell you that our firefighters should be disabled, which means they can't perform their job, that means that they have something that's going to keep them from life skills. So it's very important to stress this bill is not changing anything except for pointing out that a firefighter goes from 0 to 100. If I'm 130/90 medicated and I'm fighting a fire, I'm suddenly 200/110 and I'm having a stroke. That's disablement. Well, the problem is firefighters as a whole, if you know any firefighters, they don't want to miss work for a headache. So I would ask you to find this favorable for this bill.
Delegate Fennell.
Thank you, Vice Chair Cosby. First of all, at committee, yet again, I retired from Prince George County Fire Department after 21 and a half years, not as a firefighter, but also as a civilian, but working closely with firefighters and paramedics. Mr. Hall, question to you. Can you give me the examples in reference to the cases that you've seen in reference to hypertension?
For disablement?
Yes.
The standard used to be, when they were back in the old days, I was trained by a commissioner named Patricia Adams. It was if you're medicated, you're disabled. Because if you don't take your meds, you're gonna have a heart attack or a stroke. So that in and of itself was back in the day. That has shifted over time with the current commissioners. In fact, I just had a hearing, and Chief Arrington's here, where a commissioner, after he had a disability slip for 7 days off work, not the 3 days, the standard, no disablement. So I'm finding that and I just had another one with the deputy sheriff, not a firefighter, same thing, taken off work for their high blood pressure, which is 140/90 or higher, and they were not given disablement. And you'll hear from our opponents, disablement, they can, if they don't get the disablement in this order, they can come back later and they can file it again when they're disabled. What are we waiting for? You know, a hypertensive reaction that causes a stroke. So yes, I'm seeing it all the time. And those two I just mentioned are within the last 30 days. And we're seeing this all the time.
Good. All right. Seeing no further questions, I now have Mitchell Greenberg and James Lanier.
That's me.
Okay. Go ahead, James.
This will be easy. Good afternoon, Vice Chair Crosby, members of the Economic Matters Committee. My name is Jim Lanier, and I'm here on behalf of the Maryland Association for Justice, and we're just here to support the firefighters in this bill, so it's a me too from us.
Okay. Seeing no further questions, we'll now go to the unfavorable. Ashley Smith, Julie Murray, Michael Daly. You can start when ready.
Good afternoon. My name is Julie.
Julie, real quick, can you slide the mic over?
Okay.
Sorry, nobody can hear. Doesn't
I'm
matter.
usually loud enough without a microphone. I'll have to work on that.
Not for the three viewers at home.
Good. Good afternoon. Julie Murray on behalf of Maryland Defense Council. We do respectfully request an unfavorable report on this bill. We have submitted written testimony as well, which addresses some of the more technical aspects of the bill. I was just going to briefly touch on a few of those for your consideration. The bill as drafted, unfortunately, is contradictory to the language that they are relying on with regard to the NFPA standards. MDC notes that under the NFPA, hypertension is only considered a Class A medical condition when it precludes a person from, performing as a member in training or emergency operational environment if the person has uncontrolled or poorly controlled hypertension or hypertension with end-stage organ damage. So the problem with the bill, aside from some other issues that my colleague is going to get into, is that it is drafted in such a way that the NFPA standards actually would not find a firefighter who does not have disablement by way of being unable to perform their job to fall within that category of disabling hypertension. So we think that that is very inconsistent. Lastly, we would just note that, again, I know this was brought up when this bill was here in the past, but it bears repeating that disablement does not mean that a claim is denied. Disablement, when there is a finding of no disablement, it simply means the condition is not yet ripe for adjudication. Claimants that have a claim denied for no disablement frequently do come back again once they are disabled.
Thank you, Mr. Vice Chair, members of the committee. Michael Daly at the Maryland Defense Council. Our focus on bills like this, when it comes to our attention that there is a claim that that something needs to be changed in the law, is what do the cases show and what does the data show? And I think it's very telling in Chesapeake Employers' history and data that they gave from 2019 to 2024. During that time period, 225 hypertension claims were handled by Chesapeake. And as we know, Chesapeake is the largest private workers' compensation carrier in the state, and they insure many of the firehouses throughout the state. So if you look at that data, and it goes on to say that the majority of those hypertension cases were not denied based upon a disablement issue. So that's number one. Number two, if you look at what the commission does with these cases, there was a statement made about a 3-day disablement. I've handled hundreds of these cases for various clients throughout the state. I have never seen that raised. I've had cases where there was a half a day missed, and that was a disablement for purposes of determining that a firefighter was disabled. So I think those factors are very important in terms of what this bill aims to do. And finally, this bill doesn't prevent litigation, because under our system, many of the firefighters are paid firefighters, and they also volunteer with other houses. And when they do that, the issue of last injurious exposure, which of the firehouses and insurers is responsible party. So this doesn't eliminate the issue of when a case is determined to be compensable. For those reasons, we respectfully request an unfavorable report.
Thank you, Mr. Chair. So I'm just trying to better understand, you mentioned the NFPA, and you mentioned some technicalities. And it seems like there's a new technicality every year, because this is like the third year. And, as a bill sponsor, I'm getting a little frustrated with, it seems like we just kind of work around the edges to come up with a different excuse every year. So I'm trying to understand the NFPA that you mentioned. And I also understand that, we talk about claims being denied or not denied. We just had an assistant fire chief up here who just said does he have to die before we process the claim? Are we looking for someone to, pass out or die because of hypertension before we say, okay, this is good enough?
Certainly. I can certainly understand, and I can address the technical aspects. Each year, the bill has been a little bit different, so it is definitely, I can understand how it might be frustrating. This bill does address the NFPA standards from 2022, which is why we reviewed those standards in preparation for today and for understanding what the bill is about. So that's where that position came from. Disablement is a very fact-specific inquiry, which does make it challenging. Each commissioner is going to look at each case differently. Even within this bill, under House Bill 217, this doesn't necessarily eliminate the need for each commissioner to do that and to still review the facts of each specific case. So as you heard from my colleague and then from the other panel, if one person who might be on medications, that might be a disabling condition for them. Another person, it may not be. This bill doesn't address that problem, nor does it eliminate that problem.
Thank you, Mr. Chair, for a second bite of the apple. So do you have some language that you could, that proffer that would, clear this up?
I do not sitting here today. We're always willing to work with our colleagues on coming up with something. We did last year, and we'd certainly be willing to take a look again and see if we can come up with something. Absolutely.
I'll be happy to take a look at that because again, it's been 3 years and it seems like it's just I'll just leave it there.
Thank you. The first part of my question was going to be, have you offered any kind of amendments or something to work with them? Because, as you said, we've heard this over and over again, and it doesn't seem as though, I don't know if you are or not, but it doesn't seem as though anything has been offered to try to resolve the issue so that to address all of the concerns. So that's the first part of my question. Then the second part of my question is, have you ever had a headache that was associated with high blood pressure? And have you ever watched anybody stroke out because of their high blood pressure?
Delegate, I'm happy to answer your questions in the two parts. The first part of it is certainly this bill doesn't address what I think is missing from what the law is that there has to be a disablement in any occupational disease. That applies to, and would still apply to police officers. So understand this just applies to firefighters. So under 9503 in the presumptions, hypertension is a presumed occupational disease. So if a firefighter, after the yearly exam, their hypertension is in excess of the standards, which we don't believe the NFPA standard should be applied, because why have a static statutory provision, because we all know those standards change. So that's problem number one. And I think that if the disablement was tied in to the language, then I think the MDC would be more than happy to join in that bill. Number two, I had a heart attack in 2009. I've had disabling headaches from hypertension since 2009. So yes, I know firsthand.
It's not fun, is it?
It's not fun,
No,
but I can tell you
not.
this, Delegate, it's concerning to me that I hear that firefighters supposedly aren't getting medications because that's the first, I've talked to county attorneys, I know the county insurance is great. So I think that that's something that should be looked into if they're not getting the medication.
I would like to strongly suggest that you offer some amendments to the sponsor because this doesn't make sense that we have to keep having this going around. And if you seem to have the answer as to how this can be fixed, then offer that. Thank you very much.
You're welcome.
Thank you so much, Vice Chair. Question, is Mr. Daly correct?
That's correct, Delegate.
Mr. Daly, how many hypertension cases have you tried? I'm curious, in the past year.
In the past year, me personally, I would say estimated 8 to 10. And typically those are cases in which there's an issue as to there's multiple potential employers, firehouses that are brought in because again, the firefighter might be a paid county firefighter and yet they volunteer with 2 or 3 other houses. So the issue is when the hypertension was diagnosed, which is the responsible party? And under the statute, it doesn't state how you determine that. That's a factual issue for the commission to decide. The other part of it is whether or not at permanency. A lot of times the litigation centers around what the percentage of disability that the firefighter says they have because of that. Sometimes the numbers are too disparate so that the parties go before the commission to work that out.
Mr. Daly, I just want to say it's a lot of hypertension cases out here, and as my committee made Delegate Hurd stated, it's a lot of issues in reference to these hypertension. So I strongly recommend that you look at some amendments.
Will do, Delegate. Thank you.
All right. This would be number 3.
I'm just a soldier. I can't count. Thank you. So when can we get that language? Today? Tomorrow?
Well, Delegate, I certainly will work with the folks on the other side of this and talk to them today and see what they would be willing to work out with us.
Thank you.
Okay. Again, it is just a follow-up. Please get the language to the sponsor of the bill, and then if you could CC our office, that would be super helpful. Seeing no further questions, that concludes this bill hearing. Next, we'll go to Delegate McComas. Thank you for being so patient, Delegate. House Bill 1210, and if you have a panel, you want to bring them up, they can start.
Just a moment. We saved the last for best. No, I'm just kidding.
Yep, chair goes last, so go ahead. We got a long day.
Yes, I gather that. For the record, I'm Delegate Susan McComas, and I'm here sponsoring 1210 Workers' Compensation Evaluation of Permanent Impairments Licensed Certified Social Worker Clinical. Currently, only a licensed psychologist or qualified physician may perform the required evaluations and generate the related report that must occur in connection with a workers' compensation claim that involves permanent impairments to behavior and mental disorders. HB 1210 authorizes a licensed certified social worker clinical, LCSWC, to perform these evaluations and provide the related comprehensive report to the Workers' Compensation Commission. In doing so, the licensed certified social worker clinical must comply with the requirements of expert witnesses as set forth by the Workers' Compensation Commission. HB 1210 expands the practice area of these highly qualified and trained mental health providers, LCSWC, allowing them to evaluate only those injuries that are related to the mental and behavioral health issues. Certified social workers have completed 2 years of supervised social work practice. A licensed certified social worker clinical, LCSW, is an individual licensed by the State Board of Social Work Examiners to practice clinical social work. Practicing social work means to apply the theories, knowledge, procedures, methods, and ethics obtained through the completion of a bachelor's or master's degree from an accredited school program in social work or the equivalent approved by the Council on Social Work Education. Through the passing of HB 1210, these professionals are enabled to enhance social functioning of individuals suffering permanent mental or behavioral impairments. I would just say that I think that this bill is not anticipated to materially affect state operations or finances. It's not anticipated to merely materially affect local government operations, but it has a very high potential of being small business potential meaningful effect. Right now, there is a dearth of social workers that are able to make these determinations, and if you have to get a psychologist or a psychiatrist to determine the evaluations, it's going to be very, very difficult. And right now, I think we see within the Workers' Compensation Commission that there is a real backup. So with that, I would like to present Mr. Flack, who has a very long career in social work as an LCSWC. Mr. Flack.
Thank you. Good afternoon. My name is...
Hey, sir, yeah, I just need you kind of got to get right in it.
Good afternoon. My name is Arthur Flax. I'm a licensed certified social worker clinical. I'm registered with the Workers' Compensation Commission as a vocational rehabilitation counselor also. I want to just clarify one thing. A licensed certified social worker clinical is a separate license. There are several licenses, like categories of licensure for social workers. Under the licensed certified social worker clinical license, which is included with my written testimony, the licensed certified social worker clinical licensee is authorized to independently evaluate, diagnose, treat mental and emotional disorders and conditions and impairments under Health Occupations Article 19101 and 52, and also includes, very important here, also includes the Health General Article, Section 7.5-101, parentheses 1, parentheses 2, which authorizes that licensee, if trained, to, to be able to evaluate, as I say before, conditions and impairments in addition to mental and emotional disorders. So that what's with the Workers' Compensation Commission requirements under 9721, we are qualified to do that. So the statute includes that. We also are included in other statutes under the annotated code that allow us to make permanent decisions concerning a person's impairments. Under the Family Investment Administration, guardianship, involuntary commitment, sick leave, and so forth. Under sick leave, I'm able to determine temporary total disability.
Thank you, Mr. Flax. Are there any questions for Delegate McComas or her panel? Seeing none, thank you very much. Delegate McComas, we have Darlene McLaughlin. She's your chief of staff. Is she going to be?
Unfortunately, she is homesick, so she has that norovirus. So she's not available.
All right. Thank you very much. I will bring up the favorables. We have James Lanier, Mitchell Greenberg.
Do you wish us to leave?
You're done, yes.
Well, no, I just sometimes they let other folks talk, but, and sit up.
Good afternoon again, members of the Economic Matters Committee. My name again is Jim Lanier. I'm here on behalf of the Maryland Association for Justice. So our take on this bill is that it will potentially expand, well, it will expand the amount of people in which we could get impairment reports for permanency evaluations for mental health issues. So the way it works into the system is permanency is at the end of the claim. It's when the person has already made the recovery as best they're going to do, and they're hopefully back to work earning wages. Then they're ready for a permanency evaluation, whether that's mental or whether that's physical. For the mental health part, we are limited to psychiatrists and psychologists, which makes perfect sense. The problem is the devil is in the detail, because there's not many that do this type of work. So I believe last year, now this bill has been here in different forms the last couple of years, and last year I testified that we were aware of 3 people who were doing impairment reports for mental health for workers' comp. There may be others, but generally there's 3 names, and one of them has since retired. So now we're down to 2. And they're both in Towson. Well, one's in Towson, one's in Towson, one's in Pikesville. So we have a dearth of providers that will do these type of specialized mental health evaluations. And if LCSWCs are already trained to do these impairment evaluations, then it allows us to utilize their skill set to be able to present permanency claims, because, once we lose the last 2, then it becomes who else is going to be able to provide this service so that we can get the people the benefits for permanency that they're entitled to. Because without an impairment report, we can't go forward on permanency. It's a requirement. So we're asking for a favorable report from this committee on this important bill. Thank you very much.
Thank you. Any questions for Mr. Lanier? Seeing none. Mitchell Greenberg is with you, but he's not.
He's had to head on out. Just me today.
Okay, great.
Thank
you so much. We'll now have the unfavorables, Nancy Egan and Michael Daly.
Thank you, Madam Chair. Members of the committee, Michael Daly from the Maryland Defense Council. We respectfully request an unfavorable for this bill. The reason, primary reason why is our system is set up with specific requirements of who can provide a medical impairment evaluation. And that's in 2 parts of the statute. One which was developed by this legislature determining that the appropriate people using the American Medical Association Guides of Permanent Impairment must either be physicians or psychiatrists or psychologists. The reason being is they have the medical training and background needed to be able to evaluate and determine what a proper medical impairment is. The commission, in turn, promulgated a regulation that detailed the exact same language and specifically requires that the proper person to provide a medical impairment evaluation must be a physician, a psychologist, or a psychiatrist. Those are the reasons why we believe that this bill, unfortunately, would not be, it would conflict with the current law in two specific places. And for that reason, before the commission, that's problem number one. Problem number two is our system, as you all know, allows for either party to appeal the decision of the commission to the circuit court. Unfortunately, a social worker would not be deemed an expert medical witness for purposes of providing an impairment testimony under our law. So that means the claimant, the injured worker, would go to court as required and yet wouldn't have a medical expert that they need to support their claim for permanent impairment, whether it be they be the appealing party or the other party. For those reasons, we would ask for an unfavorable report.
Good afternoon. My name is Nancy Egan. I'm with the American Property Casualty Insurance Association, and we write 90% of the workman's comp private market here in Maryland. I echo the same sentiments as Mike just explained. And I also like to point out that this bill actually has two parts, and the one part we don't object to, which is permitting certain licensed social workers to provide vocational rehabilitation service under the workman's comp law. I understand this year, as we know, this bill has been heard, I think, for 3 years. There is a separate bill that hasn't been scheduled yet, House Bill 1404, which would accomplish that, and we would not object to that part of the bill going forward. And with that, we would move unfavorably on this current bill. Thank you.
Thank you. Are there any questions for this panel? Seeing none, thank you very much. That concludes the testimony on House Bill 1210. We'll now move on to Delegate Weigel, House Bill 1159.
Thank you, Madam Chair. I'll be brief. For the record, I am Delegate Weigel. Please present House Bill 1159, Property and Casualty Insurance, Loss Ratio, and Premium Refunds. Those in attendance during our ECM briefings in October were informed that auto insurance premiums in Maryland are higher than the national average, and of the top 10 private passenger auto carriers, rates are proposed to increase as high as 24%. Likewise, in the homeowners market, the most recent premium rates are proposed to increase as high as almost 13%. Marylanders are being pinched by rising electricity prices, increasing taxes and fees, and rising insurance premiums. The impetus for this bill is an attempt to address rising insurance costs related to property and casualty insurance premiums, and to ensure that the majority of the premium collected goes towards the actual payment of claims. In its original form, this bill advanced the concept of a loss ratio currently applied in the medical insurance market to the property and casualty market. In the medical market, an insurer is required to refund the difference between the amount paid in claims and 85% if the amount paid is less than that 85% number. I've met with various constituents regarding this issue. I realize it's a fairly complex proposal and potentially disruptive to the insurance market. Therefore, I do have an amendment that converts the requirements of the bill to that of a study to be conducted by the Maryland Insurance Administration. I thank you in advance for your attentiveness and ask for a favorable report on House Bill 1159 as amended.
I have a quick question. So you're submitting now the bill, what you just said, so it won't be in its original form?
Correct. It'll just be a study. So I have an amendment. I think it was emailed to the committee earlier today.
Okay. Any other questions for Delegate Weigel? Seeing none, thank you very much. There are no favorables here today besides the delegate. We'll now move on to, I'm sorry, what? Oh, we'll now move on to the unfavorables. Brett Leininger, Nancy Egan, Bryson Popham, and Bob N.
Sorry, I'm trying to figure out who's going to go first. Hi, I'm Nancy Egan with American Property Casualty Insurance Association. We write 71.4% of the property casualty insurance market here in Maryland, and as written, we're in opposition to this bill. As you can understand, Delegate Weibel has met with us about changing this into a study. Applying the healthcare standards of claims versus the property casualty insurance marketplace is going to have a big effect because we handle our claims differently. As you well know, we handle third parties liability where we're trying to determine in the future our loss reserves. Also, we have to handle catastrophic losses, which we have to prepare for in the future. So our loss reserves are much larger. In my written testimony, I've provided that the experience in Maryland, for every dollar paid in for auto insurance, we were paying out $1.03 in losses. So we're not making any money in Maryland in 2023. And in addition, if you refer to the fiscal note, the MIA is saying that if this bill should move forward, we could see an impact on the market with rising cost and also carriers leaving the marketplace. And for that, we move for an unfavorable report as written. Thank you.
Thank you, Madam Chair. Members of the committee, Brett Leininger, here on behalf of the Independent Insurance Agents of Maryland, testifying in opposition to the bill as drafted. I did speak with the sponsor earlier today, understood the study. Suffice to say, as drafted, it would be a market killer. I represent independent producers who are in this space. The premiums are high, there's no doubt, but it's a very competitive market. There are over 150 carriers. Health insurance and property and casualty insurance, apples and oranges. I think there are maybe 5 or 6 carriers in the health insurance market. So with that, we oppose the bill as drafted, and there is a study, I know, in Delegate Frazier Hidalgo's bill, one of his bills, 1098, to deal with affordability, the study of affordability properly. That's the issue is going to be addressed, and we think that's a better vehicle for that conversation.
Thank you, Madam Chair, members of the committee. Bryson Popham appearing before you on behalf of the Maryland Association of Mutual Insurance Companies, which is a trade association of small mutual insurers, many of whom are domiciled in Maryland and do business here. Also on behalf of the insurance agents and brokers, a trade association of independent insurance agents similar to Mr. Leininger's client. We also oppose the bill in its original form as drafted. I don't think that position would be the same in the amendments that the sponsor has suggested today. If it's a study, certainly we would look forward to the opportunity to participate and provide information we think you would need to examine the issue of affordability. It's big, it's important, and I also would commend your attention to the bill that was introduced by the chairman of the Property Casualty Subcommittee as a possible vehicle. So with that, Madam Chair, we respectfully request an unfavorable report.
Thank you. Are there any questions? I just have a quick one. So you mentioned the subcommittee chair's bill. Would that be, you prefer that as opposed to his doing a study? You want the two to merge, or?
I think his is a study of affordability, generally speaking.
Yes.
And I believe that was the impetus for this legislation. And that issue in a broad way.
Yeah, I agree. The breadth of the study contemplated in that legislation, it seems to me, with respect to Delegate Weibel, is more suitable to get at the issue of affordability. So we think that's the better vehicle.
Okay. Any other questions? Seeing none, thank you very much.
Thank you, Madam Chair.
Thank you.
That concludes the bill hearing on House Bill 1159. We'll now move on to Delegate Adams, House Bill 1170.
Good afternoon, Chair, committee members. For the record, Delegate Chris Adams here to present House Bill 1170, titled Maryland Home Improvement Commission Residential Solar Power System Installation Contractor License Required. So members, I don't know, 2 or 3 years ago, I put this in as a late file bill. Obviously, bills don't come out of rules unless they really are a great bill or a great idea. And I held on to it for a couple years, maybe waiting to see if the majority party wants to regulate on this subject on any number of different ways that we can do that. The reason why I put the bill in this year is because I gave some thought to MHIC, what it is, what their role is, why it's important for consumers, and I decided this is the year that I was going to put a bill in. I don't normally put in regulation bills, like add regulations, but here I am still, and I'm happy to present the bill. So the Maryland Home Improvement Commission has 2 essential functions that I think relate, and I won't belabor the point, but one is that there is a component that's the Door-to-Door Sales Act. And so in this setting where solar companies may be going door-to-door to sell systems, it allows for a cooling off period. It gives some protections to consumers in that space where things are being sold in their home. The other important part about the MHIC is that there's a restitution fund. So the restitution fund is a sum of money that is accumulated for which a consumer who has a damage or something goes wrong during the home improvement, they can find that fund to be helpful to bring themselves whole, and the state of Maryland helps in that regard. So in this particular setting, I think it should be plainly obvious why I'm asking for the bill. If we're going to require a roofer who puts asphalt shingles on a roof to be MHIC licensed, I'm saying that the same entity that would go through and drill holes and start mounting on top of that same roof system should be subject to those same requirements. The test is not hard to take and pass. It does require some due diligence on the behalf of the licensee to read and understand business regulations and et cetera. But the larger point is it creates a professionalism that the state can endorse as we advance these goals with solar. And I happen to think that rooftop solar is not inherently a bad thing. I think it's a good thing. I'd prefer it over, say, putting solar on our farmlands. So to that extent, I think I'm advancing the policy in a way that you might expect somebody like me would do. And with that, Madam Chair, let's move favorable.
Thank you, Delegate Adams. Delegate Pippy.
Delegate, certainly don't disagree with you. So I'm looking at the fiscal note. They said that MHEC already requires, in my law practice, we deal with MHEC sometimes for complaints and things like that.
Okay.
So are they already required to have a number, an MHEC number? I mean, are they already required to register with MHEC?
Who's they?
Solar, residential solar power.
Are you referencing under the additional comments?
Yeah, fiscal summary, state effect, says none. The bill codifies existing practices. MHEC already requires a contractor license for the installation of residential solar.
Well, they're actually, you have to go to the additional comments on page 2 because what they're saying is that MEA under a certain program called the Maryland Solar Access Program requires an MHIC license. So I'd be broadening the subject to include all solar installations. So I think that's what the fiscal note's addressing when you ask me that question.
Okay, so like right now, a residential person who wants to install solar panels on a house is technically not required to register with MHEC?
My answer to your question is they are not.
Okay.
Okay, they are not. You may argue, because if you go through the definitions that are in the fiscal note, that it talks about any number of different things. What is a home improvement? So I think you and I could read the plain language of the fiscal note and conclude, well, maybe they should. But we on occasion do, as a legislature, specifically call out.
Clarify.
And I'm doing here just to bring clarity.
Yeah, no, I mean, like I said, I don't disagree. I read that and I was like, are they already required? But if they're not, or if there's some ambiguity, this would probably clear it up. So thank you, I'm sure.
And Delegate Sharkoudian.
Thank you, Madam Chair. I just was wondering if you are also looking at the chair's House Bill 1036, which I think is getting at something similar. It's not exactly the same as what you have, but it's requires certification and standards for people doing rooftop solar. So I just didn't know if that was on your radar, if you're working to kind of see if there's a nexus there, or if this could combine with that.
Yeah, actually, I think that's probably a good conversation to have, and I would, I'm not in the business of passing bill numbers, so if we bring this bill into that bill and create clarity, I'm cool with that. I did meet with the industry who actually brought this up, and the one thing I'll say is sponsor the bill. if you're going to choose a regulatory framework to advance their interests instead of creating it, I'm not going to say out of whole cloth, because I'm sure the chair has got plans and ideas as to why it's going on. This is a proven regulatory framework that everybody seems to understand. We've had enough.
The MHIC one, you mean?
The MHIC.
Yeah, I gotcha.
So
Okay.
enough legislative framework and history that this might be, I would think, if I was a solar installer, preferred over seeing us create some unique standard. So if for some reason you would like to see this bill sent elsewhere to become law, I'm supportive.
Thank you.
Any other questions? Seeing none, thank you very much. That concludes the bill hearings on House Bill 1170. We'll now move on to House Bill 193. Welcome, Mr. Burns.
Thank you, Madam Chair. Oh, God. Members of the Economic Matters Committee, my name is Michael Burns. I am the director of your state of Maryland Uninsured Employers Fund. The Uninsured Employers Fund exists to assist injured workers and their families when employers fail to obey the over 100-year-old law in this state requiring them to have workers' compensation insurance. This agency has been an agency separate and distinct since 1983. In 1983, when I was in my last year of law school, this agency was established with a funding mechanism. 80 to 90% of this agency's funding comes from an assessment on most insurance orders, most orders of the Workers' Compensation Commission. It is paid for by insurance companies. That was the decision that was made in 1983. That is how the fund has received 80 to 90% of its funding for the last 42 years. This bill will allow the agency, the board, if an increase is necessary to maintain the solvency of the fund, to increase the current 1 plus 1% assessment to a maximum of a 1 plus 2% assessment. It will generate revenue for paying injured workers and their families. This bill is the result of the fact that during the last 2 fiscal years, the amount of the assessments received from the Workers' Compensation Commission have been down by approximately $2.4 million. That trend continues to this day. It's not like they're doing anything wrong, all right? They're not doing anything wrong at the commission. That's just the way it's going. This agency is 100% self-funded. We receive no tax dollars. So this is how the agency gets the money to pay the injured workers. I know the insurance industry is unhappy. If I were in the insurance industry, I'd be unhappy. But this is the decision you all made 42 years ago, how this agency was going to pay these bills. If you wish to change that over time, obviously that is your call. But currently, this is what is needed right now to do so. I will tell you, this is the 3rd time I've come before the legislature about this issue, starting in 2020, because I knew then that the day would come when we would have to really do it. Well, the day has come when you really have to do it. It was your decision not to, which is fine. In the past, we have an audit from 2020 that shows that the fund faced insolvency by 2030, which because of the current reduction in assessment revenue we received is going to be before then. I'm a history major, not a math guy, but I can tell you it will certainly be probably before 2030 that the fund will reach a technical point of insolvency. This is needed. I want to thank the subcommittee chair who met with me about this and has met with the administration about this bill. And there is a consensus, I believe it's accurate to say, is developed that instead of the 1% requested in this bill, that a 0.5% increase would be agreeable. And certainly the agency would be all for that. And I do want to thank the chair for her guidance, because it was very helpful. And that is the bill, and I am here available for any questions.
Thank you, Mr. Burns. Are there any questions for him? Seeing none. Thank you very much.
Thank you all very much for your time.
We do have a favorable with the amendment. We have Lindsay Menninger.
Good afternoon, members of the committee. I'm Lindsay Beidel-Menninger. I'm the Vice President of Legal Services at Chesapeake Employers Insurance and the President of the Injured Workers Insurance Fund, which is the state's workers' compensation. Chesapeake is here in support of House Bill 193 with amendments. We would support a 0.5% increase in the assessment instead of a 1% increase as written. Of note, this support is ours alone, and the rest of the insurance industry feels differently. Our support is twofold, however. Chesapeake's enabling statute by this legislature mandates that we support workers' compensation across Maryland. Based on our Chief Legal Officer, Carmine D'Alessandro's involvement in the legislative work group addressing the long-term solvency of the UEF in 2004, in which Delegate Harrison also kindly served. She was thrilled. Look at that face. We had to address the long-term solvency of the UEF. And to do that, we need to have some essential changes. You need UEF's funding, and we need UEF's oversight to ensure that injured workers without employer coverage receive necessary medical treatment and indemnity payments. So that oversight is in the way of Senate Bill 695. I'm assuming you're going to hear same in the coming weeks, so I won't bore you with the details. But the bill replaces the description of the UEF board members and mandates the UEF to establish reserves. I'm happy to go into further, but again, a couple weeks, you'll probably hear it. You'll like it, I think. So with both the 0.5% increase and those suggested modifications coming from Senate Bill 695, Chesapeake is hopeful that we will not be back discussing the UEF again in future years. So for those reasons, Chesapeake Employers Insurance and the Injured Workers Fund support House Bill 193 with amendments, and I'm happy to take any questions you may have.
Thank you. Delegate Chi.
Thank you, Madam Chair. So between the two testimonies, I realize there's a very big discrepancy. You're proposing 0.5, and he was proposing 1.5. Is that correct?
No, he's proposing 1. The bill is
okay.
1.
All right. Yeah. Are they both based on actuary and studies? And how often do we raise these rates?
Well, Mr. Burns might be better to discuss that, but as an insurance carrier, currently we pay 6.5% assessment to the subsequent injury fund and 2% assessment to the UEF. The fund has, at one point we did 0.5 less to the SIF and 0.5 more to the UEF, but that is our current state. So for Chesapeake and IWIF's data, we estimated 1.1% increase was about $900,000 yearly, just under for state and private. So a 0.5% increase would be a $450,000 yearly increase to the UEF. Now that's just Chesapeake's, which is about 20% of the market, and then IWIF, which is, like I said, all the state employees. So I don't think I fully answered your question. It's okay.
Are there any other questions? Seeing none, thank you very much.
Thank you.
We will now go to the unfavorables. Nancy Egan, Julie Murray, Michael Daly.
Good afternoon again, members of the committee. Julie Murray on behalf of the Maryland Defense Council. The Maryland Defense Council does unfortunately have to request an unfavorable report on this bill. We are certainly not immune to understanding the issues that the Uninsured Employers Fund is currently facing. However, our problem with this bill is that essentially it is penalizing the good actors in the state. The assessments are coming from the employers and insurers that have done their job and obtained coverage in the state. Part of the other problem that we have with it is that by simply raising the assessment without enacting other safeguards, one of which you heard from Ms. Menninger that is coming before you, we fear that this is just a Band-Aid, which is a temporary fix for a problem that is more systemic in nature with regard to the overall function of the Uninsured Employers Fund. I know my colleagues have some additional insights for you, but for those reasons, we would request an unfavorable report on this bill. Thank you.
Thank you, members of the committee. Michael Daly, on behalf of the Maryland Defense Council. The other concern the Maryland Defense Council has with this bill is the wording that allows the internal determination as to whether or not there are sufficient reserves to cover anticipated losses. Well, there's no outside review of that, and we know historically that's been problematic with the UEF. We've seen concerns with the financial data that have come in with the audits that have been done, and yet everything will still be held within the confines of the UEF. The MDC has concerns about that because if there's still an internal problem, what's going to fix that? And so that's the secondary concern we have with this bill. We do agree that the board changes proposed in Senate Bill 695 certainly addresses some of those concerns. However, this bill alone, standing the way it is, unfortunately, we would ask for an unfavorable report for those reasons.
Nancy Egan with American Property Casualty Insurance Association. I would echo the remarks of my colleagues. Chesapeake is one of our members, and they recognize that the rest of our workman's comp writers are opposed to this bill for the reasons already stated. And as you well know, aware that once we have an assessment, those costs will be put into our premiums to pass along to the consumers. And for that, we would ask for an unfavorable report. Thank you.
Thank you. Any questions for this panel? I'm sorry? Delegate Harrison.
Yes, thank you. Ms. Murray, you said that that it's the good actors who will be penalized, but isn't that what this whole fund is about? Those actors who have not performed in good faith and made sure that they had the insurance for the employees?
Yes, the fund does certainly provide benefits to employees who unfortunately were employed by who we're calling the bad actors, the employers that didn't get insurance. We do agree that the fund is necessary and would certainly never propose that we should not have the uninsured employers fund. Our issue is more that repeatedly over the years, the employers that did obtain insurance coverage are consistently being asked to increase the amount that they're paying into this fund when there might be some other ways in which the fund could also make changes that might help increase their funding and increase their solvency and financial viability as well.
Can you give one example of?
Yes, the makeup of the board is something that as we've mentioned in the Senate bill that's crossing over, is something that we think is really important, having different levels of oversight at the uninsured employers fund. So the way the current board is structured, I don't want to steal the thunder of the bill you're going to hear a little bit later when it does cross over, but a proposal would be to change the makeup of the members on that board, which we support. There was also a work group done over the summer that reported back that also had some good suggestions and feedback on different ways. One of them was studying perhaps whether the what's called the TPA model that they use, where they engage with a third-party administrator, whether that is a good option or whether they should look to administer the claims in-house. There were a few other things they discussed as well.
Right. And as I understand it, we have a new TPA in place, for this first quarter.
It's the same TPA, a new contract.
New contract, okay. And, I'm wondering if there have been any, because of the work group, which I did sit on, I'm wondering if, and this was probably another Mr. Burns question, but if there has been any changes with the new contract and the costs, et cetera. And I'm sure that you can't answer that, and I wouldn't expect you to.
I can't. That would be a Mr. Burns question.
Right.
I know that you're probably familiar with it as well, but
yes.
I would hope. I think he would probably have the answers to that.
And the amendment that was discussed, instead of the full 1%, I know that the bill says 1% to 2%, but I think that the agreement was for 0.5%.
That is
assessment.
That's the proposed amendment from Chesapeake.
That's the proposed
yes.
amendment. Yes, it is. Okay, thank you.
No problem.
Any other questions? Gotcha. We'll make, any other questions for this panel? None. Okay, so if you would like, Delegate Harrison and Delegate Chi, we can have Mr. Burns come back to answer your questions quickly and briefly.
I will bow to your wishes. Delegate Harrison first, because I can remember that one off the top of my head. The new contract, I was the chairman of the Maryland State Board of Contract Appeals. One of the things that contracts are supposed to do is be a total look, a new contract at what your services were, how you can change them to make them better and cheaper. The new contract that we put together does that. The administrative cost of the new contract is down by 20%, which would be approximately, for the cost of the contract, of the services, $1.6 million a year. Since you have asked, and since this bill is coming over, Carmine D'Alessandro of Chesapeake estimate during the work group, and you were attending, that it would cost the state approximately $125,000 a year in his estimation for each position. We have 12 positions. If you do 12 times 125,000, you will get $1.5 million for salaries and benefits alone, leaving you $100,000 to spend on everything else in that contract, which you cannot do. That is the cost now, $1.6 million a year for the administration of the contract. Delegate Chi, could you repeat your question? Because I'm 67 and
With that rate, I'm sure it was based on some kind of actuary assessment analysis. I just wonder how you came up with that proposed rate.
Well, as near as I can tell from my research, the rate has been 1 + 1% since 1983. We have not. That rate has not gone up over the years. That has been the maximum rate. The way it works is the subsequent injury fund has a flat 6.5% they get. Subsequent injury fund does not pay medicals. That's where our money goes, to medicals, not to indemnity, it's medicals. The UEF, on the other hand, was set up as a 1% with an additional 1% available should it be necessary to maintain the fund's solvency.
So my question was, and I don't want to take up more time.
No, it's okay.
That's not the point. The point is the rate you proposed was like more than twice as the way at what was proposed later by the next speaker. So I was wondering why the big discrepancy. That was it.
Well, there's not a discrepancy. It would be a maximum of 2.5%, but it's adjustable. And what I certainly envision is once the fund receives enough funding to get itself in a favorable position, the board would lower it back to 2, perhaps even back to 1. So it's adjustable. It's only the 1% that's mandatory.
Okay.
Delegate Barfoot, did you, okay. Okay, you're satisfied, Delegate Shi. Okay. Thank you, Mr. Burns.
Thank you. Sorry to keep you all waiting. Sorry about
No problem. That concludes the testimony on House Bill 193, and that concludes the bill hearings for today. Just a reminder to the members that we have an event about 7 p.m. Thank you.
Thank you again for your. I really haven't been in the legislature. I understand.
It's a big cycle.